3 presentations. In fact, the IC, which made a partial presentation at the last meeting, will conclude their presentation today. And of course, we will then receive the Best 100 FM and then Jamaica Lands. The morning, we want to move very swiftly because we do have a very long agenda, and the day, unfortunately, we're not able to complete everything today. I was hoping we could, but tomorrow we'll have to come back and then to take the NIA for sure, and then and Jamaica for Justice. Yes. You're not hearing clearly? Oh, wow. What have you not heard? That's the problem. Anyway, just to indicate that in terms of the way we are organizing the meeting for today, we will be taking the Integrity Commission to complete their presentation that started last week, and then the Best 100 FM, followed by Jamaica Lands. We will come back tomorrow and hopefully to do NIA and Jamaica for Justice. We are hoping, members, that we could look at the disclosure act as well sometime tomorrow, if indeed we are able to complete the 2 presentations before 1 o'clock, because Parliament meets tomorrow. It wasn't really a planned, because we did have intentions of using both days to complete the 2 key items that we have to deal with. But if it is that we have to come back after tomorrow, then so be it. But I would really like, members, for us to, when we meet after tomorrow, to really be finalizing our thoughts on the presentations that have been made, and to conclude for the presentation to Parliament of the findings of the committee. So I look forward to that. Minutes? The minutes? The minutes are before us. The minutes have been very copious minutes, I must say, very fulsome.
So moved, Chair.
So move. Seconded. Moved by Member Hamilton, seconded by Member Robinson. Matters arising from the minutes, which would no doubt be the continuation of the IC. Shall we then invite the team from IC to come in? Yes. I know. Oh. But for their thing, yes. Were we able to get name tags? Yes? All right, so you take your tags as you move along, and then so you're identified as you sit. Mr. Christie, did you see any for yourself? I suspect you should have. Well, you see, you're so protected. So I see this seating arrangement, Mr. Christie, is in the batting order, is it? Okay, so welcome the Integrity Commission, headed by its ED, Mr. Greg Christie. I note, Mr. Christie, that in my absence we had fulsome presentations of LAMP, first of all, or is it JAMP? JAMP, yes. And that the IC started its presentation, and it was truncated because of time and the fulsomeness of its content. So we will continue with you this morning, and therefore we invite you to introduce your team and then to proceed with your presentation.
And a privilege to appear before your honorable committee. The second sitting, the first one was July 6th and was chaired by Member Chuck. I bring greetings from our Board of Commissioners, chaired by Honorable Mr. Justice Seymour Panton, and I will start by introducing my colleagues. I have to my right Mr. Craig Beresford. Craig is our Director of Information and Complaints. Mr. Kevin Stevenson, Director of Investigation. Mrs. Keisha Prince Kamiko, our Director of Corruption Prosecution. Mr. Ran Evans, our Director of Corruption Prevention, Stakeholder Engagement and Anti-Corruption Strategy. Mr. Brian Taylor, our Director of Finance and Accounts. I don't know if he had any questions on that, so I asked him to be here. And our Director of Corporate Services, Mr. Ronald Salmon. Our Acting Legal Counsel, Mrs. Evian Ortiz. Evian. And last but not least, Ms. Shelley-Ann Lutus, to my left here, the Executive Assistant in the Executive Director's Office. And, I'm sorry, Mr. Maurice Barrett. Maurice is the Manager, Anti-Corruption Policy and Strategic Engagement. And among other things, Maurice is the person who puts together the annual report for the Commission. Chair, before I go, I just wanted to point out that this is a very peculiar commission as crafted by our parliamentarians. Our statutory directors, now we have 4, have special powers under the statute. Mr. Kevin Stevenson, our Director of Investigation, has special authority to conduct investigations on behalf of the Commission. The Director of Corruption Prosecution, she conducts criminal prosecutions on behalf of the Commission, and she's subject to no other person or the direction of no one except the Director of Public Prosecutions. Mr. Craig Beresford, to my right. Craig is responsible for, among other things, receiving complaints, allegations about corruption, and he also has charge of the statutory declarations that are submitted to the Commission by public officials, including parliamentarians. He starts the process of examination into those statutory declarations. And Mr. Ran Evans. Ran has a broad portfolio, a very big title, Corruption Prevention, Stakeholder Engagement, and Anti-Corruption Strategy. And I, basically as Executive Director, am responsible for the day-to-day management, administrative affairs of the Commission, and I speak on behalf of the Board of Commissioners. Chair, we're here to review the recommendations that have been tabled before your honorable committee by the Commission for the revision of the Integrity Commission Act. The Act was received royal assent in October 2017, and the Commission was operationalized in February 2018. So next year it will be 5 years old. The law, Section 60, requires that Parliament should, from time to time, via a joint select committee, review the Act. And this is the purpose. This is our purpose. At the first sitting on July 6th, we looked, well, there are 18 recommendations that we have made, and we submitted that document to your committee. But for ease of reference, we have also reproduced them in our annual report, which was tabled in the House in July of this year. And there are 18 recommendations. The first 11 are concerned with revision to the Interior Commission Act, and the other 7 to associated pieces of legislation. We looked at the first 6 in your absence, Chair. It was the first sitting. So we are now, unless there are any questions, we can go right into 7, the 7th recommendation.
Any comment from members? I think, Mr. Christie, one of our members would like to make a comment in that regard, yes? No? Okay. Right, so it's the one dated February 10, 2022, just to ensure that everybody's on the same page. And it details the recommendations, and I take it you had done a number last meeting, and you are at 7. So you will now proceed from item 7. Recommendation 7 on the list.
Yes, sir.
Very well.
Thank you, Chair. So recommendation 7 is entitled, and just for ease of convenience, as I said, these are also reproduced in the annual report of the Interior Commission. 7 has to do with review of obligation not to announce or comment on investigations. And that's Section 53 of the Interior Commission Act. It's a very contentious provision, and it has been subject to a lot of debate within the purview of the Oversight Committee, which you chair, Chairman, and also in the media. I just want to point out that for 4 consecutive years, the Interior Commission has maintained its position that it's asking the Parliament to revisit this provision and to amend it. We went as far as submitting to the Oversight Committee, and we have tabled that document before you, what we call a position paper. And in that position paper, we listed all the recommendations having to do with Section 53, which have been made by the Commission from the very outset. And that was in its 4 annual reports. And we also included an associated document, which is a commentary on the so-called Bloomberg case, which came out of England in January of this year, and which was contended to support the position that commissions like ourselves should not make our activities public, investigations public. So those are formally before this committee, Chairman, and they are formally before the Oversight Committee. The position paper, 1, 2, 3, 4, 5, is 6 pages. The commentary on Bloomberg is 1.5 pages. I would assume that the members have read it, and everything that the Commission has to say about Section 53 is formally encompassed in these 2 documents. We have also responded to the challenges that have come before the Commission with respect to Section 53. And in fact, the position paper has 15 responses, 15 items. I don't think you'd want me to go through them, Chair, but they're all here, and we're respectfully asking that these are the positions that your honorable committee, we're asking you to consider in your submission to the broader Parliament.
Chair, could I start, please? There's 2 questions related to that. The first relates to the previous incarnation of the Contractor General's Office. You used to publish on a quarterly basis the contract awards to entities who went through a competitive process and were awarded contracts. Why is it that you have stopped that? And is it that you believe the Section 53 prevents you from doing so? That's the first question. And secondly, I want to know, the current provisions allow you to report to Parliament as often as you want, in as much detail as you want, on matters that are being investigated by you. What I want to know is, why is it that you believe that provision does not give you the latitude to do your job or prevents you from acting in a way which enhances public transparency?
Thank you for your questions, member, and they are very pertinent questions. I'll take the first one first, which is why we consider that we're not in a position to continue publishing what we call our QC, Contract Award Reports. That is a matter which falls under the...
Sorry, Mr. Christie, I think that there's a little bit of concern with regards to the audibility. Yes,
oh,
I'm
you want me to
hearing,
speak
yes,
louder?
Indeed, yes.
Okay, no problem. Thank you, Chair. Can you hear me better now? Okay, yes. Yes, that matter is a matter for Section 56, which we're going to deal with later on today. Section 56 is a recommendation. I'll tell you which one it is, member. It's number 10. I could just give you a short answer now, and when we get to that provision, Section 56, I could elaborate more. But Section 56 basically says it has nothing to do with investigations. Investigations are captured by Section 53, which says you can't comment on an investigation until you table a report in Parliament. Now, Section 56, your question is about contract award reports, which we monitor as well as investigate. With respect to the monitoring activity, that falls in the purview of the QCA regime. And Section 56 tells us that we can't contract awards, quarterly contract awards report. I started it when I was contractor general. It's a quarterly report, which basically provides, we requisition data from all public sector bodies about the contracts that they've awarded in the preceding quarter. And we put it on our website. And it's a searchable database. So it's a very powerful tool, and it brings transparency to the entire contract award process. It goes back to 2007. Now, Section 56 says that with the exception of the summaries of statutory declarations that we are entitled to publish for the Prime Minister and the Leader of the Opposition, everything else, statutory declarations, contracts, we must treat as secret and confidential. I don't know if it was Parliament's intention to go that far to capture the contract awards report, but that's what it says. So on a strict interpretation of the provision, we cannot publish the QC report. And this is why in section...
Could you read the specific provision
Certainly.
In that regard?
Certainly. Section 56.1, subject to Section 42.3b, and 42.3b is the one which authorizes, actually requires the Commission to publish the statutory declaration summaries of the Leader of the Opposition, the Prime Minister. Subject to Section 42.3b, every person having an official duty under this Act or being employed or otherwise concerned in the administration of this Act, which is us, hereinafter called a concerned person, shall, it's mandatory, regard and deal with as secret and confidential all information, statutory declarations, government contracts, prescribed license, and all other matters relating to any matter before the Commission, except that no disclosure made by the Commissioner or other concerned person the proceedings for an offense under this Act or under the Perjury Act shall be deemed inconsistent with any duty imposed by this section. And it goes on to say that that obligation up to, for secrecy and confidentiality, survives a person's tenure at the commission. So even after you leave, you can't talk about it. And here's the important one, member, which is subsection 3. Every concerned person who is required under subsection 1 to deal with matters specified herein as secret or confidential, who at any time communicates or attempts to communicate any such information, declaration, letter, or document, or thing referred to in subsection 1, disclosed to him in the execution of any of the provisions of this Act to any person, other than a person to whom is authorized on this Act to communicate it, or otherwise, and for the purpose of this Act, commits an offense, and shall be liable upon summary conviction in a parish court to a fine not exceeding $1 million, or to a term of imprisonment not exceeding 1 year. It's a criminal offense.
Have you sought legal advice from the AG's department on that particular provision?
I'll give you the short answer. Our commission is composed of 5 commissioners. 2 are retired justices of the Supreme Court. I'm a lawyer. I'm a trained lawyer. We have come to a considered position on this provision, and that's the commission's position. What we're asking the Parliament to do through this committee is to review the provision and to state specifically what matters are excluded from its purview. And that's what we have in the recommendation that we're coming to. We just want it to be very clear, but right now, the literal interpretation of the provision is that the only exception to that provision where we can speak about something is when we do a publication of the statutory declaration summaries for the Prime Minister, Leader of the Opposition. Section 53.3 speaks to investigations. You can't comment on an investigation until the report is tabled in Parliament.
Well, I'll await when we get to that provision, because I don't think that was the intention of Parliament, to have something as routine as that to be taken out of the public's view.
Fair enough.
So when we get to that, I'll comment on that. The second part of my question.
Yes, I made a note of that.
Can I just ask a very short question, which you don't have to answer now if you don't have the information. Since 2018, the enactment of this legislation, approximately how many claims or allegations or complaints have you received on an annual basis? About what proportion have you found it necessary to start an investigation? So the next question is, how many investigations have been started since 2018? And next question, how many of these investigations have you found that the allegations are well-founded and therefore you pursued them, and to what extent, what proportion of them have been completed and reported to Parliament? Because to the best of my knowledge, I have not seen many reports come into Parliament of many completed investigations. So could we get some figures, if not even now, at an appropriate time, so we have an idea what is happening with all these investigations?
Certainly, Member Chuck. I'm going to ask Director Craig Beresford, who is the responsible functionary for receiving complaints. No, for receiving complaints. No, not no. He's asking for information at a later date. To make a note, and then Director Kevin Stevens, who is responsible for investigation.
But I mean, these figures should be easily available, at least how many investigations you have been conducting and what proportion of them you have completed. Because the final question is, have you been impeded in any way in pursuing them?
Well, Member Chuck, the annual report, if you have read it, carries that information on an annual basis, because the law...
The final result, but it would be nice to know how many complaints
for the
you
entire
get.
period.
Right.
Okay.
And what proportion you...
That's something that
and what proportion you investigated.
Absolutely.
And then of those you investigated, what numbers you concluded, which is what you have there. So you only have the third answer to the third question in the report. We don't know what proportion in the first and second. Okay?
Okay, Member Chuck. I will ask both persons to put that information together, and I will make it available to the committee. Yes, sir. The other question that you had related to Section 36.3 of the Integrity Commission Act. That act says,
Well,
that provision.
is really about you can now report to Parliament as every day if you want to, but the Commission has taken a view that you need to have the quote-unquote gag clause reviewed and removed. What I'm asking is, with the provision where you can report to Parliament on a regular basis, how is that impeding the work of the Commission?
Okay, thank you. As I indicated previously, the position paper that we have tabled before this Parliament addresses every query that has been raised with respect to Section 53. And if you look at the position paper that we have for Section 53, and you go to number 8, you will see the response to the question that you've just asked. And I'll just read it for you, if you allow me. Government members of the Integrity Commission Parliament Oversight Committee have reasoned that instead of seeking to remove Section 53.3 gag, the Integrity Commission should utilize the facility of a special report to Parliament under Section 36.3 of the Act to make announcements of its commencement of investigations. The argument suggests that once the report is tabled in the Houses of Parliament, the announcement of the investigation would thereby become public. However, if the mischief that the gag is seeking to cure is to prevent the tarnishing of the reputations of public officials by prohibiting the Commission from making a public announcement of its investigations, then how is this mischief cured when the Commission is allowed to make the same public announcement via the tabling for report in Parliament? Is not the presumed offending public announcement made in either case? And we continue. Let me just finish, please. However, of even greater importance is the fact that the Integrity Commission was upbraided by the Parliament Oversight Committee, this is a formal document that we tabled, for not following the law by its failure to use the facility of Section 36.3 to announce its investigations. A proper construction of Section 36.3, however, discloses that the section was never intended for that purpose. This is what it says. The Commission may at any time submit a report relating to any particular matter which, in the opinion of the Commission, requires the specific attention of the Parliament. The qualifying words are, which, in the opinion of the Commission, requires the special attention of the Parliament. However, the Commission's announcement of an investigation is not something which requires the attention of the Parliament. Section 36.3 cannot, therefore, in the Commission's view, be lawfully used in such circumstances. And then we go on to make this point. The recommended authority of the Commission to make an announcement of the commencement of its investigations or to otherwise make guarded comments concerning its investigation is something that is intended for the benefit of the public, not Parliament, primarily to inform it of matters that are under consideration by the Integrity Commission. And we make this very important point. The Commission's making of such announcements will, among other things, ensure that members of the public, not Parliament, who are in a position to assist the Commission in its investigations, can come forward and do so. This serves the public interest, for if the public is not aware of what the Integrity Commission is doing, its capacity to effectively function is thereby undermined. That's the official response of the Commission on Section 36.3.
I must respectfully disagree with that opinion, because you can, whether on a monthly or quarterly basis, you can indicate that you have commenced 4 investigations. You are, up 2 of them, you're making progress and you expect to complete within X period of time. There are another 2 that are taking longer, without giving very specific information which could be prejudicial to the individuals involved. Secondly, I don't think you need to name individuals at all. You know, if it relates to a particular entity, you can speak to the entity without calling the name of an individual. And Parliament is public. Anything tabled here is public. So, you know, I don't see a distinction between saying you're doing something for the benefit of Parliament versus the public. Once you table it, the clerk has to publish it. So I don't find that a strong argument of why you can't use the current provision. I don't at all.
To pursue that and make it crystal clear that you can present to Parliament what adjustment would you propose to either 53 and 36. And the reason why, it's a matter of process. If you present it to Parliament and it becomes public, you're protected. The alternative, if you want an open-ended, you publish as you see fit in the press, would you support a provision where you agree that an investigation is being pursued and it turned out to be ill-founded, that compensation must be provided to the persons who are affected wrongly? In other words, would you support, if you say remove 53 and 36, you're free to publish and do as you see fit, would you support adjustment to, I forget the clause now, where if the investigation turns out to be ill-founded, that compensation to be assessed by a court of law or by a tribunal must be paid by the IC to the person who is affected?
Member Chuck, any funds that the IC has, the government funds. And so that's where the money will be coming from. But is there any other organization that you're aware of in Jamaica who is subjected to what you just described?
All, because if the police force or FID go and engage in arresting people or doing things that are negligent, as Minister of Justice, I see so many of them come in for claims, malicious allegation, in the court by the police, and we have had to be paying out, and the Attorney General Chambers have had to settle matters where people were malicious allegations. And moreover, the best example really of what I think should be pursued is the Auditor General, who have said, don't send out press releases. That office complete their investigation, report to Parliament, and the benefit of their reports, as Member Robinson will know, exposes problems in the public sector. And they're given wide-scale publicity once they're tabled in Parliament. But I don't see the Auditor General sending out regularly that they're investigating ministries. They wait, and at the end of each year, or at the end of a period, they send a report to Parliament, and I think Member Robinson will know, you go through it at the PAC in great detail to demonstrate how problems exist in the ministry. So my concern is process. As a Commission of Parliament, use Parliament. Send everything through Parliament. So to the extent I would go with you totally to make it clear that you can report on any investigation to Parliament, I would support that. Because as a Commission of Parliament, so rather than a press release and members going on the air and talking about, send the thing to Parliament, and then everybody can discuss it afterwards.
Member Chuck, if I could just point to a couple of things. The Serious Fraud Office in England, which is the equivalent to our Integrity Commission here, this is what their policy statement says. It's not long, I'll just read it for you. It states that the following are circumstances in which it will exercise its discretionary authority to make announcements about its investigations. I give you two. One, and I'm quoting, when there are operational reasons for announcing the investigation, quote, such as a call for witnesses. Or, two, where there is some other substantial reason why the announcement of the investigation would be in the public interest. That's England. Australia, which is the latest Commonwealth country to embark upon the course of establishing a federal anti-corruption commission, it's a federal country. They have states, and, like Victoria or New South Wales, they have their integrity commissions. But Australia has been battling for years to establish a federal anti-corruption commission. And 3 weeks ago, the bill was tabled in Parliament by the incumbent government. And here's a big debate. The bill, as it's stated, allows the commission to conduct its investigation hearings in public in exceptional circumstances. Director Kevin Stevenson is authorized by this act to conduct quasi-judicial proceedings. He can call witnesses, they have to give evidence. If they lie, it's a breach of the Perjury Act. That's done privately. In Australia, their bill, tabled by the government, requires the commission, allows the commission to do it in exceptional circumstances. But there's been a big debate since the bill has been tabled that what the independent members of the Parliament are asking for, what the integrity organizations of the country are asking for, what 84% of Australians that did a poll 2 weeks ago are asking for, is for all inquiries to take place in public. And I would just call your attention to that, Member Chuck, because it's a parliament of the Commonwealth, and to see what their perspectives are in terms of doing things like this in public. I circulated this document. Actually, it happened on the same day that we had an oversight committee hearing, October 14. This was a matter in which a government minister called upon 2 law enforcement agencies in Jamaica, one of them being an anti-corruption agency, to conduct an investigation. When I was Contractor General, I did a special assessment of 21 major investigations that I conducted. And 8 of those investigations were in response to calls from parliamentarians in this very house or outside for us to investigate matters like this. And then we responded by announcing that we have started the investigation. 5 of the remaining 13 were actually allegations were made in the media. And we, as we are here to do, we don't make allegations. Our job is to investigate allegations.
Right.
One second, member. And what you're saying here, as I said, the argument is that when we announce an investigation, we are damaging reputations. We are not the ones who announce the investigations. Here is somebody asking for an investigation to take place. And one second. I have several of these, and our position is quite simple. We respond to say we have started an investigation.
Executive Director, that's the problem. You see, because I can tell you, and I don't want to relate, 2 matters where persons did not get contract, and they felt there was corruption. They had full-page advertisement in the newspaper asking the Integrity Commission to investigate. You will know one of them has to do with fire brigades. The second one has to do with whether $1 billion meal contract was provided. I know you investigated because the people were. But if you had said we are investigating, it gives credence to the allegations. It gives credence. But those things, to the best of my knowledge, pass. I know the people are performing the contract well, to the best of my knowledge. But if you had said we are investigating, which I know you're doing, it means that something was amiss. You see, later on when you come out and say it was ill-founded, it still doesn't exonerate the parties who could have been implicated. Now, just to conclude, one final comment, and we can move on. We talk about our Commonwealth countries. In New Zealand, which has similar serious fraud office like Australia and Britain, this comment is noteworthy. The Serious Fraud Office will not generally comment on an investigation until the point where charges, if any, are filed. Why? A statement that the Serious Fraud Office is investigating a person or entity can cause damage which cannot be redeemed even where it is later decided there's insufficient evidence to commence proceedings. And that is the point. Once you say that you're investigating, reputation is immediately damaged. If it is turned to be well-founded, those reputations should definitely be damaged. But if it is ill-founded, it is impossible to redeem the damage. And that's the concern. And I'm just saying, what I would like to hear from the Commission, that's just my view, what adjustment so that everything can be passed through Parliament to protect you, protect the IC. Because once it's passed through Parliament, it's privileged. You see, that is my concern. You do it out there in the press, you're not protected, and you open the government to suits, lawsuits. And that's my concern, Chairman.
Thank you for the comments. Member Guy?
Thank you very much, Chair. I must also apologize for being late. I had to attend to a gruesome matter in the constituency this morning. Director, in response to a question that the member from Southeast St. Andrew asked earlier on, you indicated that in relation to Section 36, that when he asked whether an opinion was sought on the interpretation of that section, you indicated that the Commission is comprised of a chairman of a retired president of the Court of Appeal, High Court judges, and you pointed out that you were a lawyer yourself. But there's a maxim that says that you should not really advise yourselves. And the truth is that I would feel more comfortable if you had indicated that there was external advice sought, whether it is privately or from the AG's department as to the interpretation of this particular section. Because, not because the entity is comprised of those grace of respect, eminent individuals. The reality is that opinions outside of it ought to be utilized and then presented to us, or as in the case where it to be tested, presented to the courts for them to make a determination.
Thank you, Member, for your comment, and which I respect. I would just respond that there are many things in the daily affairs and operations of the Commission. It's a big statute where the issue of what this section means or what it doesn't mean arises. And we make that call. It's just that this one is a public issue. We're debating it. But I would also like to say that we're a creature of statute, which means that we're circumscribed by the law. And if we subscribe to the rule of law, Section 6.3 of the Act says this: in the exercise of its powers, and this is what Parliament prescribed, in the exercise of its powers and performance of its functions under this Act, the Commission, A, shall not be subject to the direction or control of any other person or authority other than the courts by way of judicial review. It's an independent commission of Parliament. And that's a big difference to a public body who, on legal issues, is required to seek advice from the Solicitor General's office, from the Attorney General's office, under which you have the Solicitor General. The Interior Commission is an independent commission. It's a big difference. B, to hammer home the point, it shall act independently, impartially, fairly, and in the public interest. And so some may hold the view that if there is and with all respect to governmental authorities, that as an independent entity, typically what should happen is that it should seek outside advice. It can go to the Solicitor General, it can go to the Attorney General, but because it's an independent commission, it has to act independently. So I'm guided by what you have
But
said,
C
member Guy.
goes further, sir, which says, shall have the powers to do all such things as it considers necessary or expedient for the purpose of carrying out
Exactly.
its function. You could
Exactly.
seek an opinion externally.
So the commission was of the view that there was no need to. That's the point I'm trying to make. And as I say, it happens every day. We make interpretations on the provisions of the Act. It's just that this one is in the public domain.
Can I, coming back to the point I raised, I feel your interpretation of the perception of your effectiveness is flawed.
Okay.
Meaning you believe the ability to announce commencement of investigations will give the public confidence in the work that you're doing. I will posit that what will give the public confidence is the completion, the prosecution, and the arrest of people who are involved in big criminality and corruption, not the small fryers, right? With respect, I mean, I've seen, you have to do what you have to do. I've seen people prosecuted over delays in filing statutory reports. Hopefully that will improve the compliance. But what I would really want to see is where you go in depth and where you hold people accountable. That is what will build confidence, not a flurry of announcements about commencements of investigations. That's how people will know that the $1 billion that has been spent annually on the commission is value for money. What you complete, who you prosecute. And that's why I believe the provision that allows you to report to Parliament as often as you want, in as much detail as you want, in my view, is sufficient to keep the public aware of the work that you're doing.
Sorry, I go further, Chairman.
Member.
No, I just want to support the point. If there needs to be any tweaking of those provisions that you can report to Parliament every week, every day, let us know. Because I think that's the proper process.
So member, I wanted to make a comment in regards to, the line of investigation discussions as they flow. One of the purpose, of course, of us listening and hearing your presentation is to inform our own position after we meet to review what you all have said. I want to urge we avoid pejorative comments which suggest, any kind of value judgment or any, rightness or wrongness, but rather to investigate, to find out what are the thoughts behind what is being said so as to guide us properly to conclude on a position to report to Parliament. I just wanted to make that comment.
Thank you very much, Chair, and I really appreciate that. And basically, that's all the Commission is asking. These views that we have put before you are not mine. They are not us. They are the considered views of the Commission, the Integrity Commission, and they have been consistent views for the 4 years. Well, in February, we'll be 5 years old, of the entire life of the Commission. I'm not authorized to override it. I hear the comments, and we have accepted them, and we are guided by them. What we would respectfully ask our chair and members is that the document that we have tabled to support or to try to explain why the Commission has taken this position over 4 years, going into 5. These are the sort of justifications. So we're prepared to leave it at that. Chair, I will ask our Director of Investigation, Mr. Kevin Stevenson, to present this one for us here. Director Kevin. Number 8. Actions of the Commission void for want of form. This is a matter, this is a provision, which is Section 22 from the Contractor General Act, which, yeah, you're good? Okay. Chair and members, basically I'll just read out what the recommendation is. The Integrity Commission Act has repealed Section 22 of the Contractor General Act, and no subsequent and equal provision has been provided. Given the complexity and variety of matters being treated by the Commission, it is recommended that the Act be amended to include the provision that the proceedings of the Commission and/or a director shall not be rendered void for want of form. This, the Integrity Commission is an amalgamation of three previously existing commissions of Parliament. One was the Commission of the Contractor General, the Corruption Prevention Commission, and the Parliament Integrity Commission. Under the Contractor General Act, all the powers that a Contractor General had have now been subsumed into the authority of the Integrity Commission's Director of Investigation. And so there are a number of provisions that were associated with the administration of those functions, the Contractor General's functions, that we are respectfully asking the Parliament to bring over into the Integrity Commission Act, and this was one of them. Section 22 of the Contractor General Act.
Do you have Section 22 of that Contractor General Act?
Yes, I'm just pulling up the Act here.
If you read it quickly, then
I can, yes, Chair, I can do that. It simply says the proceedings of a Contractor General shall not be rendered void for want of form.
Yeah.
So basically what we're saying is that the proceedings of the Director of Investigation shall not be rendered void for want of form.
Okay, so the recommendation is just to include that simple provision somewhere in the Integrity Commission Act, okay? Yeah, no problem with that.
Thank you very much, Chair, for your kind considerations. Number 9, regulations to the Integrity Commission Act. I will ask Mr. Barrett.
Sorry, 1 second. Perhaps, because I just came in, I'm just trying to get a grip of what we agreed to a while ago. Okay. So,
I guess what the member is saying is that probably we need a little bit more as to why it is required in this legislation. Even though it was in the previous, why is it now that it's required to be transferred into the new legislation?
My response, member, is that, as I explained, the Commission of the Contractor General, lock, stock, and barrel, has now been subsumed into the Integrity Commission. And the functions that were previously exercised by a Contractor General, all of them are now exercised by the Director of Investigation. And for the same reason that Parliament saw it fit to have this provision in the Contractor General Act, we're similarly asking this Parliament to afford the Director similar facility in the conduct of his inquiries and investigations.
Yeah, but there must be a reason why it was excluded in the first place. So maybe what we need to do is to go back and check to see the reason why this particular provision was excluded, because there must be a purpose of having form or process. And so what I saw, Member Chuck, or my understanding is that it's not that we've agreed to it, but maybe we need to do a little bit more research into the history surrounding that particular legislation before we can proceed.
I agree with member, but to be frank with you, if a matter is to be rejected for form, I'm not too sure that's substantial. Right? We're looking for substance.
Yeah, but what is form then in this situation? Because I'm very concerned, because a lot of things can fall down on procedure.
I think, yes, it will be considered. I think the member has correctly pointed to the fact that the omission had to be based on something substantial, as all matters that have to be considered by the judicial process, very deep and serious consideration is taken. So for it to have been omitted, there had to be a reason, and I think perhaps what the committee would want to know is what's really behind, which is the point I made earlier, if you recall, that our purpose is really to go behind what is being put forward so that we better understand how to adjudicate in favor or otherwise.
Chair, thank you, and member, thank you. We're very comfortable with that approach, Chair. As you have rightly corrected, we're here just to make recommendations. And there's something that I left out at the beginning, and I think it's important for me to say it, that it is the job of the Integrity Commission to actually do what we're doing. Section 6 of the Act, Section 6.1, requires us, 6.1H, to monitor current legislative and administrative practices in the fight against corruption. 2, to advise the minister on what? Yes. Section 6.1 of the Integrity Commission Act, which sets out the functions of the Act, specifically in H and J says this: we are required to monitor current legislative and administrative practices in the fight against corruption, and then to advise the minister on the adoption of international best practices relating to the prevention of corruption, and then to advise the minister on such legislative reform as the Commission considers necessary to reduce the likelihood of the occurrence of acts of corruption. So I just wanted to say these are the things that have guided our recommendations. And we're quite comfortable, Chair, with your approach. As we were saying, it's for your committee's consideration, and then, to determine what you put to the wider Parliament. And we thank you for the opportunity to put this forward. And we appreciate the comments that are made.
Member Golding.
Sorry, thank you, Chair. Yes, I just wanted to ask a question, Mr. Christie. If you can explain, really on the back of Member Hamilton's question, what does 22 mean in the Contractor General's Act mean by want of form? Are we talking now about documentation that should attend any circumstance that the Commission is investigating, or are we talking about form being things like notice, etc., etc.? Form is broad. Was there a consideration as to what defined form?
Okay, as a former Contractor General, I could comment on how that impacted my work, and I would ask Director Kevin to speak on how he would see a provision like this facilitating the discharge of his responsibility. Basically, as Contractor General, you had certain powers, and basically the Contractor General was given the powers of a judge of the Supreme Court, and you had the authority to summon witnesses and to swear them under oath, except that you did not have to go through the strictures that you typically have in a court of law. I, for example, would issue requisitions to persons who I would want statements from. And it was backed up by Section 29 of the Act, which basically stated that if, someone should refuse to comply with the lawful provision, that's how we built up the QCA regime, Quarterly Contracts Award. When we started and we sent out the requisitions to the heads of public sector agencies, I can tell you this, there were roughly 198 of them, and we asked for a response. It was a quarterly report that they were to give us within 30 days of the ending of each quarter. and the first quarter fell within 2006. And the response was 26 agencies, 26 out of 198, a 13% compliance rate. What we did was that I went and I met with the Director of Public Prosecutions, was then Mr. Ken Pantry. And only the Contractor General Act was a provision which says that if you fail to comply with a lawful requirement of contract against a criminal offense. So what we did was that we began to serve notices, zero tolerance notices on public officials. And to cut a long story short, when I demitted office, we had 100% compliance for the 13 preceding quarters before I left office, except for one quarter. So we were able to bring a semblance of compliance. And that is how we built up the database that Honorable Member is now talking about, that we can no longer publish. But you could do things like that without, without the strictures. We decided how we did our investigations, and we decided how we got information within the law, but you're not bound by the strictures of form.
So I'm trying to understand what is the form that you want waived under this provision.
What I'm saying, member, is that you have the authority, for example, to conduct inquiries.
Yes, but is the manner of conduct, what is prescribed that you want waived? Because it would have to be some prescribed form that you're saying ought to be waived.
There's no prescribed form. That's what the provision is saying.
Right.
There's no prescribed form. And that's how that act was developed by Prime Minister Golden. There's no form.
And I'm not saying that there ought to be. I'm just trying to understand what this request is intended to do. So if there is no form, then why is this provision necessary?
In other words, are you saying that the provision here is redundant?
No,
and therefore you're just requiring that it not be brought into the new
With
list?
that provision, you cannot be challenged on an issue of form.
And form meaning what? Due process? Are you calling form due process?
Anything.
So you're saying that in the conduct of the Integrity Commission, it ought not be encumbered by the normal due process requirements that would attend the principles of natural justice, etc.?
No, I wouldn't go that far.
Wouldn't go that far.
No, I would
so
not.
That's what I'm trying to understand.
I would not go that far.
That's what I'm trying to understand.
I would not go that far because you have to comply with rules of natural justice. For example, giving somebody an opportunity to be heard.
Yeah.
But Director Kevin can speak as to how he conducts his hearings. It could be that he probably calls in somebody, and he wants to call him in tomorrow or next week. And that person could say, well, you haven't given me enough notice. Right. I have had several situations as Contractor General where persons refused to comply with your request. But it was backed up by a provision which says once it's a lawful request, I'm not asking you to do anything unlawful, you have to comply. Right. And that's how you brought order and compliance to the public sector.
But in the conduct of your investigations, though, your requests would meet a reasonable standard. I mean, you wouldn't be sending a request at 5 p.m. for someone to attend a 9 a.m. meeting.
I don't think so.
Right.
And remember, I'd asked Director Kevin perhaps to speak as to how he would see this provision benefiting his...
Thank you so much.
Thank you very much.
Thank you, Edie. Chairman, members, other attendees, morning. The issue of formalities is not something that is limited to the investigation division of the Commission. There may be other divisions, for example, the Information and Complaints Division that issues certain prescribed forms, for example. The Investigation Division, however, does quite a bit of this kind of activity as part of its processes. Insofar as not making for an inquiry void for want of form, I could think of, and it's a good segue into number 9, when the regulations are drafted, for example, let us say that there is a procedure in regulations that says that A should be done followed by B. Let us say that B is done first, and it doesn't prejudice the complainant or the accused, for example, as long as the process can be seen as a good process done in good faith, then there should be no reason at all to say that the proceedings are void for want of form, simply because B was done before A, for example. So that is one limited example.
So if I could just interject, Mr. Stevenson. Yes. So really then, it's not a blanket, the proceedings should not be void for want of form, but should not be void for want of form where that waiving of the form does not prejudice the person whom you're investigating.
Indeed.
In other words, there's a reason why it would prescribe that A is done before B. And that was part of the thinking when the legislation and the regulations were promulgated, right? So to say that the process should not be void for want of form really does wipe out that entire section. It basically says you're really not required to comply with that section. So it sounds to me like what you're saying is for administrative errors or failure to follow the administrative process, so long as it's not prejudicial to the person, the proceedings should not be void.
Indeed, member.
I'm clear. Thank you so very much.
You're very welcome.
Right, but I think perhaps a very careful definition might be necessary here so as to avoid confusion, because if you appreciate the extent of the discussion here and the varied positions that could be read into it, you will appreciate that for the purpose of what you do, and especially how sensitive what you do is and how it affects people, we have to be as precise as possible. So we will take that in consideration when we are making our determination on this particular recommendation.
Thank you very much, Chair. If you want us to move on to number 9, I will ask our acting legal counsel, Mrs. Evian Ortiz, to speak on this one. Evian, please.
Chairman, members of the committee, other parties present, colleagues, good morning. As highlighted in the Commission's 2018-2019 annual report, we wish to amend Section 64 of the Integrity Commission Act, which provides that the Commission may make regulations subject to affirmative resolution. The Commission is of the view that the regulation should be made subject to negative rather than affirmative resolution. Now, as the negative resolution may provide for the regulations to be passed in a shorter period, this would be of greater benefit to the Commission as we are seeking to codify our processes or practices or procedures in a timely manner. If there are no questions, I'll defer to Mr. Christie, who will now speak further on Section 56. Thank you.
Any questions, members? Member Goldie?
It's not so much a question, Chair, but I do recall some time ago the Parliament had moved in the direction of moving away from the negative resolution process to an affirmative resolution process, because it was felt at that time, and I'm talking probably about 10 years ago now, it was felt at that time that that affirmative resolution process made for more interrogation and scrutiny of the regulations that would come to Parliament. I don't have a strong position on this, to be quite honest with you, but I just put that on the table for consideration because negative resolution processes, though quicker, do sort of lend themselves to a flight out of Parliament without the ability of some members who would wish to have, deeper debate on the issue. For your consideration.
Any other comment on that?
Chair, I probably have a different approach. I am of the view that it is incumbent on us as parliamentarians to try to be as prepared as possible, especially when it comes on to these types of resolutions, because we've had instances, certainly since I've been here, where we've been able to interrogate the negative affirmation. So for me, I don't have an issue if it is negative or positive.
This one isn't contentious, so I think you can move on.
Thank you, Chair, and thank you, members, for your kind considerations. We're now back to section 56, number 10, and we had spoken about this provision before. Do you want me to repeat it? This is the one.
Just say what the recommendation is specifically.
Okay. Okay. The section 56(1) prohibits us from, requires us to treat as secret and confidential a whole wide variety of matters, contracts, statutory declarations, and so forth and so on. The only exception that it gives, and it is in the preliminary words of section 56(1), is that it's subject to the Commission's obligation to publish the statutory declaration summary of the Prime Minister and the Leader of the Opposition. That is the only exception that it gives. All we are saying, and I think, member, you have the same concerns that we have, because we do not think that it should have gone as far as, shutting down something like the publication of the QCAs. But upon a clear and literal interpretation of the provision, the only exception is the exception with respect to the publication of the summaries. That's the only exception. So what we're saying here, and I'll just quickly read what we have. The Interior Commission, having reviewed the provision, is of the opinion that due consideration should be given to amending it with a view to achieving a proportionate balance between matters which are deemed secret and confidential, that's a term that they use there, and should rightfully be treated as such. We're not asking for a carte blanche removal of the provision. And the broader objectives of openness and transparency, which are crucial to anti-corruption efforts and are deemed to be international best practices. In giving consideration to this recommendation, we're asking that due regard be given to the broad anti-corruption and public education mandate given to the Interior Commission vis-à-vis the role of transparency in key areas of its work and the international thrust towards open government initiatives, amongst other practical anti-corruption principles. The continued carte blanche inclusion of Section 56 within the Act is in contrast to the principles which are espoused by anti-corruption authorities, inclusive of the principles of being able to communicate and engage with the public regularly in order to ensure and secure public confidence. That's coming from the Jakarta principles, which are guided, governments all over the world and interior commissions are guided by. And members, you share the same concern that we are having, because we are saying that we don't believe it was the intention of Parliament to capture so many things into this restrictive hole. And then we say the participation of society in the fight against corruption, which incidentally is strengthened through, and I'm quoting from the United Nations Convention Against Corruption, through enhancing transparency and promoting public participation, ensuring the public has adequate and effective access to information, and the undertaking of public information activities and initiatives. The intention of the recommendation is to allow the Commission sufficient latitude to execute its mandate, whilst also responsibly facilitating transparency in key operational areas which will complement the work of the Commission and build overall public confidence in the anti-corruption efforts. One of the things that we face, and I've always said this, is that a lack of transparency in government institutions, undermines things that we all want. We want to build trust and confidence on the part of the public in all our national institutions, in Parliament, in government, in law enforcement, in our anti-corruption institutions. One way of doing this that everybody will tell you is transparency. Bad things happen in the dark. even in our organization, if people do not know what is happening in the Integrity Commission, we will in time be open to charges of misconduct, of acting in bad faith. So it's very important for us to develop mechanisms and structures where even we at the Integrity Commission are able to, and this is one way, the oversight committee is another one. And I fully subscribe to that because it gives us an opportunity to face members of parliament and to answer your questions. Today we have a representative from every division of the commission, corporate services, accounts and finance, because we want to be open, because we understand that if there's a perception that you're not transparent, the public will lose confidence in us. And we're saying right here, member, and you're quite, I'm happy that you brought up the point because we're ad idem. We believe that this provision has merit in a lot of ways, but it has captured too broad a field. That's
Chairman,
what we're saying. So all we're asking, at a minimum, is for you to create the exceptions.
Yeah.
Leave it and create exceptions.
No, but Chairman, may I just say, let me say that my recollection when this was put in was to try and avoid speculation. Any little tidbits that come out of the Integrity Commission could create a lot of speculation, especially about allegations and complaints. And I certainly agree with you that the work of the Integrity Commission should be open and transparent and that the public should know about it. How could we adjust it to say something like save and accept what the IC considers appropriate to be sent to Parliament? In other words, what I would like to see is a regular reporting to Parliament, not necessarily our annual report, but if you have something that you're conducting or you feel that there's a contract and you need more information and persons can be invited to, make representation or contribute towards the investigation, that you report it to Parliament and indicate that the matter is unresolved because you're still awaiting persons to give additional information, something like this. But always, you will see my position always, is that the matter should be addressed to Parliament. That's my concern. So how can we adjust this section to make it crystal clear that you can report to Parliament your concerns, your requests, the state of the investigation once it is done through the procedure of Parliament? That is my position.
Okay, thank you very much, member.
Can I just add, I think we should explicitly state as an exception something like the quarterly routine publication of contracts, which would have gone through a public procurement process, which is a little bit separate from what Deborah is saying. I think that is a clear exception. I do believe other matters that you're dealing with, there is a requirement to maintain secrecy and confidentiality up to the point of publication of an investigation and completion. But certainly I think we could pull that as an exception for sure.
Yes, thank you, Chair. I am the principle of disclosing government contracts and prescribed licenses. I am of the view that the public can already obtain information through the ATI, subject, of course, to certain exclusions. So I personally don't see why the Integrity Commission is prevented from disclosing these, subject to the same exclusions as the ATI. Now, in terms of the manner in which it is done, maybe that is something that we can discuss. But the principle of the disclosure itself for contracts and the licenses, I have no difficulty with that.
Okay, so we seem to be getting a consensus that this particular recommendation has deep merit and to be considered indeed, and that we will make suitable adjustments, subject, of course, to your further guidance, because I do think that the elements of your own mandate are so deep and wide that it in fact impacts on special and critical areas of government operation which may need to be considered confidential and secret in the public interest. So I think that it is important for us to consider these and to create for you an architecture that will allow you to make appropriate disclosure through the Parliament of these areas, bearing in mind what are those, what can I say, sacrosanct clauses that cannot be divulged in the public interest.
Grateful to your chair and members. What I'm
Sorry,
here.
sorry, Mr. Christie, member. Yes. Motley, your mic. Yeah.
How was it usually done? When you used to post it on the website, what sort of information would you have included there?
Okay, thanks for that question, member. What I conceptualized was to bring transparency to the government contract award process. When I was contracted, there was a provision which says that we must monitor, not investigate, monitor all government contracts. But when I looked at the last report that preceded me, the annual report, there were only 300-odd contracts that were reported on. So I figured that there were many more contracts that nobody knew anything about. So we started with a value threshold. You remember what it was, Craig? It was $250,000. And I came up with, we wanted to get the information, but we didn't want to burden public bodies. So we came up with a concept which says you give it to us after the fact, 1 month after the quarter. And we created a spreadsheet with 12 columns. And each column was designed to give us information which could do two things. One, we could over time build up a database of pertinent information having to do with government contracts where you could now go online and you could put in the name of the contractor, you could put in the name of the agency that issues the contract, you could put in a value band, you could put in something which says, tell me how many sole source contracts, so forth and so on. And so there were 12 columns to be filled out for each contract. It's a simple spreadsheet, and that's what we required. And it was not on legal size paper, it was on letter size. And we required each public body to send that to us 30 days after the end of every calendar quarter. And then we would input the information. Now, over the years, we transitioned to an electronic format. And I'll tell you what happened. Public bodies would come to this parliament, and they would speak about the grades that we gave them, because we would grade public bodies. So, you'd have grade bands. You remember, Craig? So if you got 82, because the way we built up the red flags, we could sit at our desks and basically monitor the government contract process by looking at the algorithms or the red flags that we would build in to tell us if it's something that we needed to go and visit that office, or if we needed to trigger an investigation, depending on how we would score them. And so 80 to 100, you're looking good. But let's say it's 0 to 20 or to 30, that would trigger an investigation. And so over time, it helped us to monitor government contracts without more personnel. We use technology to enhance our capacity to monitor government contracts. That's one. And secondly, we built up this massive database. I heard the members speak about an ATI request. The beauty about this database is that, I don't remember the number, but Director Kevin, who know, we're still doing it, it's just that we don't publish it. But when you put it on the website, it means anybody in Jamaica could freely go in and query it, and you could put in the name of a government contractor, and it will tell you how many contracts that person has gotten from 2006 up until now, who issued them, the values, whether they were sole source or they were competitive bidding, the whole 9 yards. So it's a powerful tool. And we had public bodies who were scored high, and they would come here and they would say we were scored high because we were passed by the Contractor General. So it had very many benefits to it, but that's how we present the information. It's an electronic database, and media can go and search. Anybody can search. What's that?
Well, you know, the hard cold facts are team that this new information and knowledge age that we're in has created a level of transparency that is awesome. So what was yesterday even regarded as proprietary information is no longer so. As information has moved, what they say, from the center to the periphery. Everybody now has access. And so what we have to do is to manage this whole process and to create the ethical rules that guide how that data and information is transmitted and made available, so as to protect the rights of individuals and institutions. And I think that is the frame in which we are seeking to guide you in terms of how you adjudicate this particular provision that you seek. So we have a long program ahead of us with you. I see there are at least 8 more clauses.
Chair, before you move on from this one, can I ask a question?
Yes, I will allow you, but
you.
I just want us to be mindful that we have 2 other presentations before the day is out, and we are only halfway on this one, unless... Right. Mike.
I'm sorry. We have 18 recommendations, but 11 are associated with the Act. The other 7 are germane to the Act. They speak to amendments to other pieces of legislation. So in terms of what's proper before you, it's 11. You could look at them, but we wouldn't have to go through them here. You have them documented. Yes, Chair. Yes, Chair. Yes. So, and that way we could expedite the proceedings.
So quickly, Chair, I just wanted to ask Mr. Christie if he could just give some guidance. When cabinet submissions, cabinet notes, am I calling it the right name? Huh? Right, are tabled in Parliament, or the report from the cabinet. It's the report, right, are tabled in Parliament on cabinet decisions. When I read them, I often see the notice of a contract awarded, cabinet has decided. What's the context, do you know, under which that is included in the cabinet report? Is it just contracts of a certain value? Okay. And the amount would be?
Yes, the government of Jamaica maintains a value band, and depending upon the value threshold, it has to go through various tiers. So, like, the first tier is something that a public body can do on its own.
Right, yes. So I know that. So it's only the ones that cabinet, that have to go to cabinet for cabinet approval that are reported. Okay, yes. I'm aware. Okay, thank you so much.
And the Public Procurement Commission, they take care of the ones in between.
Right. And then just on the next point in relation to those recommendations that touch and concern other pieces of legislation, are you saying they're germane to the Act, or they're essential consequential amendments that you're proposing to support the ones that you've already proposed?
Your latter comment.
Thank you. In that case, Chair, I think that we would need to hear from the Integrity Commission on that.
You want us to give us 10 minutes?
What I'm saying, I offer okay, the moment for us to discuss a little bit on it, just after 11 is done, so we can determine whether they are substantial enough to consider, a longer period of discussion, or it is one that we could ourselves review and make a determination on in the report that we're going to print. That's what I figure we could perhaps do. But we'd allow you to make a general comment in regards to the proposals that you're making for these consequential amendments without detaining you for any serious interrogation, right?
Okay, Chair, which
because
one?
Time is of essence.
Yes,
this is what we're saying.
Yes, and I don't want to detain the proceedings either.
All right.
I just want to make just one comment on the thing that we just finished. There are two categories. I guess Member Chuck wants us to, or you're going to be looking at what we can pass through Parliament. But then there's another category where we're asking for specified exceptions to be made, like the QCs, to give that which doesn't go through Parliament. And, you know, things like land divestment, license issued by the government, those are things that we have mechanisms, we capture information, and we'd like to make all of that public so anybody can see it.
But that would be in the public space somewhat anyway, because government decisions are public.
Yes. So we'd like to be able to put that on our website, so you could see what assets have been divested, what licenses have been issued, what contracts.
Chair, I'm sorry, a quick one. Mr. Christie, when you send something for tabling in Parliament, what's the timeline between your delivering it to Parliament and when it's actually tabled? Is there any lag?
No, never that we have experienced. We know the House meets on Tuesday sometimes.
Okay.
They meet other days on Parliament. We have a report which is coming in today, for example.
And
I know
it will
you're
be
not
tabled
meeting
today.
but yeah.
Tomorrow, okay.
Yes, yes.
Okay, that's
It
important.
always happens in a week unless you're on vacation or recess or something like that. Yes.
Okay, thank you.
Yes. Yes, there's one. There's an interruption. Just one more then, Chair. This one is very easy. It's number 11. And this is something that is coming from Turks and Caicos Islands, where I was. Huh? Well, if you find out that somebody knows something I didn't say it.
Can you define public official for me under the Act?
Craig, you want to take that one? It's all of us.
No, I would anticipate all of us here, but I don't know. Is it every civil servant, every
Yes.
government employee? What do you mean?
Go ahead.
Chairs, honorable members, definition that is now in the ICA is that public official means any person holding an executive, an administrative, or a judicial office, or a parliamentarian, whether appointed or elected, whether permanent or temporary, or whether paid or unpaid, and any other person who is employed to a public body, and any member of the security force. And the security force means the JCF, the JDF, and the rural police.
In the time, I might say, because you may have matters say that, let us say that public official is aware of in the department, but rather than reporting it, they allow the person. Sorry? No, what I'm saying is that there are many allegations of misconduct, including corruption, and most agencies, once they find out, they just get the person to resign. You get me? Because they do it because of their position. And I mean, there are dozens. Now, if you do that, to say that, you know, you allow the person to resign, you should have reported it, and therefore, since you did not report it, you're going to be fined under this act, could be a bit dangerous. I mean, what I mean by this, you see, it may well be, let us say in a ministry, you're aware that a person is engaged in corruption. The whole ministry is aware. But you deal with it by getting rid of the person who resigned. So the matter has been dealt with. But if it comes to the information of the IC, you could then charge a whole ministry or members of the ministry under this provision who is aware of the corruption, did not report it, but found a way to resolve it. So I'm a little concerned how you deal with that.
Before you answer, so for example, Mr. Beresford, a member of a school board would be considered a public official? Would a member of a school board be considered a public official? a teacher in a school. I just want a teacher would be, but not a board member. Would not. But a board member of a statutory organization in the public service would be considered a public official? No? Okay, it's someone who is employed and who, because you said voluntary to, you know.
I want the ED to speak.
Board members, there's, no, I don't know. Yes, yes, member. We had gone to the Solicitor General on this one.
So you choose which one you go to and which one you don't go to.
I'll tell you why. I'll tell you why. Because it had to do with whether or not the commissioners are required to file statutory declarations. What's that?
Are the commissioners required?
The Solicitor General said no.
Yes.
Yeah. And that is, on that one, the chairman directed that the opinion should come from the Solicitor General.
You understand the inconsistency in your positions because you opted not in a previous case, which I would say there's
a concept called conflict of interest. This is something that would impact the commission.
But I would say the first one is also a conflict of interest.
Which one is that?
In the sense that the commissioners chose to take their own legal advice versus an independent, the government's lawyer in the first case.
With respect to Section 36.3,
yeah.
That has nothing personally to do with anybody in the commission. It's just a process that the commission goes through. In other words, Section 36.3 speaks to what you have to put before Parliament versus what you can openly speak about. This now has to do with what are required of the commissioners themselves. It would be highly inappropriate for the commissioners to advise themselves on that. And I think our chairman did the right thing.
John Doe, based on the response just now, and in light of what it is that we're discussing in relation to the, how is it that that there was not a proposal then to remove the commissioners from not disclosing within your submissions here?
The recommendations that we have here are the recommendations of the commission. These are the
so ergo we're having a problem.
I can't, no,
because
I can't respond for the commission, the commissioners. I can't respond for them. These recommendations are recommendations that are here with the authority of the commission. When I started my presentation, I pointed out that this Integrity Commission is specially structured. The 5 commissioners that constitute the Board of Commissions, the powers and authority of the commission reside in them. There's a provision here which says that every director is subject to the general and special instructions of the commission, unlike private sector boards, for example, or even public sector boards. If you look at the government corporate governance framework, the GOJ's corporate governance framework, the board set policy. In this case, the commissioners can give general and special directions to any director except for the director of corruption prosecution, who cannot be directed, save and except by the director of public prosecutions, who has the final authority under the Constitution for criminal prosecutions. So
there is also no position as it relates to the staff of the IC as public officials and them reporting?
The staff of the IC, and I can say this, are 100% report, the staff. Yes.
So the only...
As a matter of fact, I can go further, member. from I was a contractor general, we had a strict rule. If you did not file, you would lose your job. It's that simple. So we have had a 100% compliance rate. I know that the Integrity Commission has amalgamated 3 commissions. Every member of the as a matter of fact, we can't even recruit you if you have not filed. If you look at any advertisement that the Commission puts out, a prerequisite is that if you're being recruited from the public sector or if you spend time in the public sector, you have to show that you have been up to date with your submissions.
The only anomaly then would be the commissioners in this situation.
Yeah. I can't speak for the commissioners, but I can speak for the staff.
Chairman, Chairman, just to follow, if you would allow.
I have to listen to you. That's your first intervention.
Arigato gozaimasu. Domo arigato. As it relates to the section 79(1) and 2 that is recommended from the Turks and Caicos Ordinance, Mr. Christie, referring to a public official who knows or suspects that another person has been, is or is likely to be engaged in an act of corruption, and having the mandate to report that knowledge or suspicion. I'm just asking, I don't have the actual research on how it has been treated with in other jurisdictions, but I wonder whether the mandate for somebody to report a suspicion would not lead to some a range of issues where the probative value might be outweighed by the prejudicial. It doesn't say even reasonable suspicion, just whatever you suspect. Guide me as to how you would treat with this matter.
Member, it is for the committees and the Parliament's consideration. As I indicated previously, part of our mandate is to look at best practices in anti-corruption in other jurisdictions and to see what it is that we could reasonably propose to the Parliament to consider as perhaps a measure to curtail acts of corruption. I understand I don't have the particulars before me, but this concept, I don't know if anybody could help me, but I gather it's not our Sexual Offences Act, but I gather that there is a similar requirement for somebody who is in a position of, what's that? I can't hear. Child Care Act, who knows, for example, if someone is being molested or whatever, that you need to report it to the sexual offense.
I'm not concerned with the no, and I was very specific in that.
No, it's the same principle. Or reasonable suspects or knows to.
But this is what I'm saying. It doesn't say reasonably suspect. I was very clear with my question, and I even gave the example of whether it said reasonably. And again, my concern arises not from the intention. It's clear. I mean, we're looking to widen the net and create as many perspectives that will allow for us to lead to the ultimate goal of being able to reduce corruption, cauterize it. But in doing so, how we construct the clauses in the legislation can give room, sometimes inadvertently, to persons who may not have the same intention, being given a platform to create mischief. So I'm simply saying here, it does not even include reasonably suspects, as you, in your natural inherent articulation, said, because that is your intention. So I'm not questioning that. I'm just saying, based on the fact that you have put it forward here, how would you see it from construction to action? Do we have the benefit, or do you, or have you had the benefit in terms of submitting this, of seeing how it has been applied in other jurisdictions? Just asking for that.
I take your point. What we have reproduced here is a verbatim provision in the TCI legislation. This is something that you can amend if you see fit. And I take your point about the qualifying term, reasonably suspects. again, it is something that it's a decision for you. All we're doing here is repeating what we have seen in another jurisdiction. And to answer your question, if I was there for 2 years, no, I never had cause to, initiate a charge under this provision.
Chair, just on this issue, I would...
Member, just before, if you will, lady.
Thank you very much, Chair. Mr. Christie, you mentioned prior to now that all members of staff submit declarations, and it's a requirement for them to be a part of the agency. But you also mentioned and submitted that you adhere to the conflict of interest principle. Who do these staff members submit declarations to?
I'm going to ask Director Craig to answer that question. Under the law, he is a functionary in the Interior Commission who has expressed responsibility and authority to receive statutory declarations and to conduct preliminary examinations. Director Craig.
Thank you very much, ED, Chair, members. The law specifically states that it's the Director of Information and Complaints that is responsible for receiving and keeping on record all statutory declarations filed and also to examine them. So the issue of conflict of interest, when I was appointed to office, and I know that it was identified before, we found that we would be in a conflicting position to be reviewing our own statutory declarations. So as it stands, though, they have all submitted. We have made proposal for regulations to remove ourselves from the process. And that was already submitted to the Office of the Prime Minister or the Administrative Office. So those proposals are there now, which would remove us. So we have not touched them.
I don't understand. Go further. Remove yourselves from what exactly?
From the examination process.
So who would do it?
Well, those proposals
based
are
on, if I understand what he's saying, he submitted
Yes.
that proposal to the OPM, which
Correct.
is administratively responsible for them, and they are waiting a determination therefrom.
Correct.
So we have taken note of that. I certainly, as chair, will investigate further to see what steps are being taken and where we are with that. Because I think it is a legitimate question that has been put as to what happens with the declarations for members of the commission.
And Chair, it's interesting because here's it now, we're complying with the law. The law says he's to receive everyone. And we're now, the point that the member just raised, despite the law requiring that, it raises a conflict of interest, which we have identified and which we are seeking to have it addressed.
So why wasn't that a proposal for the legislation itself?
No, that is
for there to be an exclusion.
It's coming through section...
Rather than the regulation.
It's coming through section 62 because section is 62. And it has already been submitted. If you look at 62, it's 64, I'm sorry, 64. The Commission may make regulations, which one it is, yeah, B, amending the form specified in the third schedule. And C, prescribing the procedure and manner for the filing of statutory declarations by the Commission, directors and staff of the Commission. This is the regime which the Interior Commission Act lays out. So we treat with it in accordance with the provisions of Section 64, which is to do it through regulations. I trust that answers the question, Chair.
Yes, I was just myself reading the relevant section here in the Act. And
that is why we didn't put it here.
Yes.
We have submitted it through the Office of the Prime Minister.
Correct.
The next step we advise is to bring it before the Chief Parliamentary Council.
But to the extent, of course, that the Office of the Prime Minister may advise any further legislative or regulatory amendments, then it can come back to us.
I don't know, because the Office of the Prime Minister is the administrative ministry for the Interior Commission. If you look at the schedule of...
But then somebody has to say correctly,
yes,
where does the report go for review?
It comes to Parliament.
No, but so I see. So all the submissions of the staff members would come to us in Parliament for review? Would come to the committee I chair? Okay. I think that's a little cumbersome. I mean, for us to be considering the staff of 179... That would
If I may, Chair, that is not the proposal that it will come to Parliament for review. We have made certain recommendations first to treat with who examines. Within the structure of the organization, we have what we call a chief internal auditor, and that person reports directly to the board. We have one commissioner who is also a public official, and that individual files by virtue of that position.
I tell you something.
So we have made certain proposals to ensure that there is no conflict of interest. And
right. I see an issue here, and I know that it might not be the remit of this JSC, but certainly it would be the remit of the committee I chair in my substantive position in
Chair,
Parliament. So therefore, I will be looking at it, and I think that it is correct that there should be some external body that does the actual review other than what the law now prescribes. So if indeed there is need for an amendment, then that would be done. But I will also consult with the Minister of Finance, who has the broader responsibility, as you know, for this, for the mechanism for the review.
But
Chair, if I may qualify, not necessarily external body, but someone who is not in a conflict position.
But Chair,
no, we will be guided.
Chair,
we will be guided on that.
I still believe that that proposal should still have been brought to us for the regulation, for the legislation, because as it is now, only one person is able to investigate or receive. What's your role? Well, the role within the legislation would either have to have some qualifications or something. And I believe that a proposal of that nature should be brought to us.
Given that this is a JSC, I think we can, in our report, recommend to Parliament the appropriate steps to be taken, and then the legislative amendment is done. Because it hasn't been brought to us as a consideration formally. So what we can do is, in our report, we make reference to that and to indicate that there is need for us now to establish a mechanism to ensure the oversight that is done.
Chair, just on a point of clarification, and you'll be happy to hear this. One of the documents that we formally tabled for this committee is the third schedule. And our proposals for that, and that addresses the statutory declaration. So it's already before you. The third schedule of the Act is what outlines the statutory declarations. Yes. And that's alluded to, is before this committee. Shelley, you remember the day we said it?
Could you point us to where that is?
It's here all over. It was submitted. Shelley's right here.
Is it a special report to Parliament which would not have been included in the considerations of the JSC? No? What do you find? Where is this from? It is part of what came to us? Oh, I see. All right. So we do have something here, yes. A special report to Parliament on the status of statutory declarations, a corrected version. But that's November 2, 2021. That's a long time ago. All right, I take note of this, and we will move to have the correction. I think members have correctly pointed to that gap, and we will move to fill that gap.
Sure. On Clause 11, I'm a little reluctant to agreeing to this. In life, you have a carrot and you have a stick. We have a Protective Disclosures Act, which is significantly underutilized in the public sector for a variety of reasons. I think there's still a perception that people are under this Official Secrets Act, and that prevents them from highlighting areas of corruption. I would prefer to, through a process of public education, use that as a basis to encourage public servants where they see incidents of corruption to report it, and the Act gives them that protection. But right now, since we have passed the Act, and I think Minister Chuck could speak to it, we have had very few instances of the utilization of that. So my preference would be the carrot rather than the stick with respect to encouraging persons to report incidents of corruption.
So that doesn't require a response, I'm sure. That is what we are informing ourselves as the JSC when we consider these recommendations for report to Parliament. Thank you, Member.
On this last point, on the last recommendation, if I could just ask a final question. My understanding, though, of the Protected Disclosures Act is that it does not enshrine in law a duty to report. It enshrines a mechanism of reporting that is protected. I stand to be corrected, but my recollection of it is that you are not under a duty that is criminalized if you do not act. However, Mr. Christie, you submitted the TCI ordinance. Could you just, so I can have a better appreciation, are there any other jurisdictions that you looked at that have a similar provision, and are you aware of how it has worked in practice? Because even if we amend it and add all the reasonable and all that kind of limitation language to protect people, are jurisdictions really using this, particularly jurisdictions like us, small island state, with all the attendant neighborhood qualities that comes with?
Thank you, ma'am.
Sorry, can I, in fairness to you, because I think you went there and you pointed out also that what you have done is to put on the table a best practice as you saw fit, and it is for us now to consider and determine whether or not we support this and therefore include it in our amendments. So I think that pretty much he initially said to you he hadn't a chance himself to see it at work, and even in the TCI where he had been for 2 years, he hadn't a chance to prosecute in this area. So we are taking your suggestion in the context of how you put it, and this is one of the reasons we try to go behind why you have put forward these things. And we are beginning to get the view that perhaps this one has not been carefully and deeply examined, and therefore we're not giving you a position right now, but I think you get a sense of where we are, indeed.
My final comment on it would just be that I believe the resources that you have limited in a country like ours should be used primarily to find the people who are engaged in corruption, principally. And I believe you would have a lot of difficulties. You would tie up a lot of man and woman hours trying to prosecute people here.
On suspicion.
I would just add to the Chairman. I would like to, Minister, IC members, for you to utilize the Protected Disclosure Act more by advertising and probably get a toll-free line, something like 888 corrupt, so people who know of corruption can call 888 corrupt and give you information, so that the problem is that half of them will be malicious, right? But at least get them to let it be known that we need to expose many corruption and get it. Your commission needs to be more, better known, so people know that they can report corruption to you. And I would say you advertise regularly, something like 888 corrupt, and let people know that they can report to you on a daily basis any acts of corruption that they know.
Very well. So we have to move on now. The C, recommendations for amendment to other legislation. And I think we had commented earlier that perhaps the committee can review, and if you wanted the executive director to give us a quick overview of all the, is it 1, 6, 8? My God, 10. But time is of essence. I think you'll appreciate it. Yes.
Thank you, Executive Director. If we start with recommendation 12, which speaks to the debarment or suspension of contractors who are found to be participating in fraudulent practices, particularly with respect to government contracts. I suppose that it goes without saying that if you are convicted of an offense for fraudulent conduct in respect of your engagement with the government of Jamaica through contracts, then really and truly you should not be rewarded in the future with other contracts.
Yes.
So
I think you can work with that. That's not a problem. Okay, next.
The Public Procurement Act, recommendation 13, speaks to, well, before the Public Procurement Act 2015, there are a number of documents which governed or guided how government contracts or the procurement process should really be administered. One of those documents is the Government of Jamaica Procurement Guidelines. By virtue of the Public Procurement Act of 2015, some of the guidelines in some of those documents became null and void. However, what you don't see in the new act, for example, is guidance on how some of these procurement activities should be undertaken. And we can look at things such as force accounting, whereby public bodies utilize their own resources to carry out works instead of going to, for example, public procurement in terms of utilizing that methodology. So there's no guideline on that. I think this activity was governed by ministry papers, but those ministry papers have now become outdated as a result of the Public Procurement Act and also the regulations. What is necessary, and of course the legislation cannot be relied on to guide all the processes in any sector. And so what is required is some detailed guidelines akin to what existed before the Public Procurement Act, the Government of Jamaica Procurement Guidelines, which put together a comprehensive set of guidelines which should be read in conjunction with the Public Procurement Act and the regulations so that there is guidance on almost every area of public procurement. So that is what is, there's a gap in that area and we are recommending that that gap is filled.
No, go ahead. We take note of that recommendation.
And then we go to recommendation 16, which a recommendation in which we are asking that the Integrity Commission be listed as an entity that can receive information under the Interception of Communications Act. I believe the Chief of Defense Staff and the Commissioner of Police are two persons who are listed, and we find that this kind of evidence is very helpful in investigating and ultimately prosecuting corruption offenses. So it would make it easier for the Commission to be listed as an entity that can receive this information instead of necessarily utilizing Section 48.4, which of course some persons will interpret in a way that would prevent the Commission from obtaining the information with ease and simplicity.
I think for this, some very more careful examination would be required. And in the context of this recommendation that is before us, and even the competence of the JSC at this time, I don't think we are going to be in a position to give you any position on it now. But certainly it's a matter to be looked at because it has to do with the issue of interception of telecommunication data and information. It has to do with ethical concerns about the rights of people to public data and so on and so forth. So this is a very involved one, and we take note of what you've said, but we wouldn't want to give you any undertaking insofar as the JSC is concerned on this account.
Fully appreciated, Chairman. Thank you.
Sorry. I'm going to ask our Director of Corruption Prosecution, Mrs. Prince Kamiko, to address items 14, 15, 17, and a part of 18 for me, please.
Thank you, Executive Director. Good morning, Chairman, members. Recommendation 14 was born out of an attempt to preemptively counter possible challenges in the prosecution of matters in light of intended digitization of the organization's processes and against the background of what has typically been a general wariness with regard to the courts and their attitude with respect to digital evidence. So the most recent amendment to the relevant section, Act 16 of 2015, sought to afford the prosecution greater ease, I would put it, with regard to marshalling such evidence with the use of a certificate with respect to the computer-generated evidence. The challenge with that, however, is that it departed from the common law presumption that the devices were to be deemed in proper working order. So what that resulted in is a possible exclusion of probative relevant evidence if the device itself was unavailable. So we have submitted, it's our considered position that we would be better off codifying the common law presumption, or at the very least repealing what has since been provisioned. That would be for recommendation 14. If I may move on to recommendation 15. That is an easy one. The relevant section 50, subsection 1 and 2 of the Integrity Commission Act references the Witness Expenses Act with regard to daily rates. And at present, the first schedule of that act has class 1 daily rates starting at $1. I'm sorry, at $1.40 at the lower end and $14, class 4 at the higher end, which clearly a daily rate. Yes, Member Robinson, which clearly needs to be addressed. So it's just a request that be brought up to date as soon as possible.
AG department, could you make a note of these things, please? All of these.
While you are at it, at 14, perhaps would want the Minister of Justice to take a look at that.
No,
that one has implications.
Actually, I can deal with all three matters. Now I've had a chance to. All three matters are being dealt with, really. The Evidence Act is being brought up to date, so it conforms with modern digital.
Right.
Much appreciated.
Technological. Okay, Mr. Foreman, just remind me, please. And the witness, I mean, that's a question of updating figures. Yes, and sir. 17, definitely, yes. With the new Committal Proceedings Act, it's not only for you, but also for Indicom and
that
others.
Is correct.
You know, so it's just that we need to get it done, okay? So all three matters been dealt with.
Much appreciated, Member Chuck. So that would leave then only the first part of 18, which speaks to sentencing guidelines. And as members may well be aware, the most recent sentencing guidelines issued from the Chief Justice sought somewhat to deal with corruption matters. As it stands, it references only the Corruption Prevention Act and was silent on the Integrity Commission Act, which is, deemed an oversight. But certainly in that regard, we would ask that the sentencing guidelines would be brought up to date in that regard.
That's not a problem. Mm-hmm. Okay.
Obliged.
So fortunate in that you have in the JSC the Justice Minister with all the authority.
No, the Attorney General's chambers to advise.
Exactly. So I think that's good. So I think we have had a very fulsome presentation by the IC. One question.
There's three
please.
Items left, Chair. B, C, and D of 18. And those are the straightforward recommendations for new offenses to be inserted under the Act. They speak for themselves, so we need not
detain ourselves. This is why I looked at it in the context of 18 and heard what the Justice Minister said. Yes.
In other words, there's a general updating of a lot of these legislation. So these will be taken into consideration, and I just asked Mr. Foreman to just make a note of this so he can be in discussion with Mr. Bailey in the office, so we update them as soon as possible.
Right.
Yeah, my final question related to statutory declarations in the special report. Can you indicate what constitutes a certification of a statutory declaration and what would constitute a situation where you cannot or you would not certify a statutory declaration?
Mr. Beresford to speak on that. But before he starts, I just want to make, one statement. There's a matter which is now in the media, and the position of the Commission on that matter is that it has no comment. So outside of that, Mr. Beresford, or Director of Information and Complaints, I'll ask him to.
Well, no, may I intervene? Because your intervention, Director, is, I think, very critical in this regard. And bearing in mind that this meeting is not a private meeting, and it is therefore in the public space. So if indeed you are under constraints in terms of your own utterances on the matter, I'm not sure, member, if you wanted to either rephrase or otherwise, review the question that is put to the IC.
Clearly, I'm not asking about any specific case because I can't. I'm just asking generally. If you look at page 3 of your report, the heading Special Report to Parliament on the Status of Statutory Declarations, it makes reference to what prior to certifying a statutory declaration. So I'm just asking what are the circumstances generally under which it is or it isn't.
So I think, member, you would be very generic in terms of your response.
Thank you very much, Chair. I will go back to the functions of the Director, who is responsible for examining all statutory declarations. And the Director is also responsible for making inquiries as he considers necessary to determine the accuracy of a statutory declaration, which means that we would do our own third-party checks. So as a matter of process, we can go to section 42 of the legislation. And this speaks to the examination of a statutory declaration to ensure that it complies with the requirement of this legislation. It also speaks to the Director requesting further information, and he may. He does not have to. He may. And he also wants to determine the accuracy of the information submitted in the statutory declaration. I'm on 42 now. Yeah, 42. And there are several ways we do our third-party checks. Our third-party checks are done with entities that we establish a relationship with on the one hand. There are others that we can require the information under Section 7. And then the legislation also provides that we can get information from other jurisdictions. And this is done through FID. Of course, these processes, these various processes, they have their own timelines. So as we undertake our examination and do our third-party checks, and the law goes on to say once the Director is satisfied after that process, he makes a recommendation to the Commission.
Can I ask a question? And then, I have in the past, maybe you're still looking at mine this year, but I have in the past got a letter from the chairman saying your statutory declaration has been checked, and so I know that I can't recall getting any for this year, right? It means that you're unburdened with all your work to ensure everything is fine. But more importantly, having got a certified, let us say you certify 2020, for example, can I say that previous ones, like 2016 or 2013, are satisfactory? The reason I'm asking, a number of parliamentarians have been complaining that in recent times you have been asking for information
of matters that have been dealt with in 2010, 2011. But, you know, I mean, I don't want to call names, but you know what I'm talking about. So, to my mind, but they in the past or in recent times have got certification of recent statutory declarations like me. I mean, once I get 2020, I would presume that everything else have been satisfactory. Is that the case?
On the face of it, yes. Because, of course, you can appreciate, we may get information that you may have provided false information some time ago. If we get that information, it's a matter that we would probably pass to the investigation, which is the commission itself, in older statutory declarations. So, as it stands, yes, on the face of it, and that is why our chair has made the decision that he would include in the attestation, and it is also in your certification letter that the process does not constitute an audit, which is a deeper investigation. So we try to look at the third-party sources that we have at our disposal, and certainly without information, we may not know all of them. So possibly, yes, on the face of it. However, if we get information, we have to explore that.
It is a burden on parliamentarians who have spoken to me that having been certified, the commission is asking for revision of matters. You know, a good example is how much did you dispose of a car for in 2013? You know, all of that, I mean, I don't see how that...
As a part of our examination process, we do what we call financial analysis to determine whether or not your asset is disproportionate to your income. And we can go back as far to make that determination. So we need the information to get that true picture. And the certification process only started under this new legislation. It was being reviewed before, but there wasn't any formal certification process. So when we start to examine, we will go as far back as we need to. And sometimes it's based on information that we have.
Yeah, okay, I think...
Chair, if I may, I just want to ensure that we all leave here with the same understanding. As it regards the exemption, it's not only commissioners, it's also board members. So I just want to place that on the record.
No, I am of that view, actually. And the position that I am taking on it is to have a review of all, so that in keeping with our desired objective of having full transparency, you know, we account for everyone, and that's very important. So I want to thank you again. I think this was a very beneficial, nearly 3 hours.
Chairman, I'm so sorry to delay you, but I just have one question on the interception recommendation. Who are the designated persons currently? Are you aware of that?
I know that the Commissioner of Police and the Chief of Defense Staff are designated persons.
Okay, so other than the JCF and the JDF, there are no other bodies who are designated?
I'd have to double check that, member. I'm sorry, I don't have that information.
Okay, thank you. Grateful if you just send a note. Thank you so much.
Okay, will do.
Okay, thank you very much, IC. And we will be reviewing and making our recommendations to Parliament appropriate. As a matter of fact, I think you can prepare yourself for another possible appearance when we're doing the final wrapping up. So, yeah. But I think in all fairness to you, we would like to have you back just for that moment. So we are pretty much at one on the way forward.
Chairman, on that occasion, we won't have any others attending. It would just be, okay. I want Mr. Christie to have good time.
Chair, Okay. Chair, I just want to say that on behalf of myself, my colleagues who are here, and the chairman and commissioners of the Interior Commission, we're grateful for the opportunity to appear before you and to answer your questions. And we're always willing to be here. And the Oversight Committee, whenever those proceedings are recommenced. And we're also waiting, I think there's a joint select committee to review the Public Disclosures, Protected Disclosures Act. We're ready and waiting for that as well. But thank you very much. Yes. Okay. All right. If unfortunately you have a board committee meeting tomorrow, right? Okay. All right. But Director Craig will be representing the Commission along with the legal counsel for those proceedings. Yes, because his division, we have established a unit in his division. It's already staffed with a skeleton staff, and they're actually doing work. Yes. Okay. Thank you, Chair and members. Thank you very much.
Yeah, I know, but are you of the view we should take a 5 minutes break for coffee or something? No? They are here, yes. Okay. Can you invite the... Who is the other group? Yes, no, we said thanks and you responded, so it's... I know you like to be with us, but...
Good morning. Good morning. The chairman just stepped out briefly. Should be back shortly. But in the meantime, if you don't mind, could you, from Bess, could you just introduce yourself and then we can begin? Okay? Mm-hmm. Go ahead.
Morning. Good afternoon. Percival Palmer, one of the presenters on the Morning Connection. Percival Palmer.
Wonderful. And Mrs. Minette Lawrence. And Mr. Lowell.
Good afternoon. I'm Lowell Lawrence,
right.
the producer of the Morning Connection.
Now, I know you sent us a paper, okay?
if you don't mind, rather than reading the paper, could you highlight the main issues in the paper, okay?
Oh.
All right? So you're going to do it, Mrs. Lawrence?
I will start, sir.
Yeah, right. Just highlight the main issues.
Good afternoon, members of the committee. I'd begin by first thanking you for the opportunity to participate in your proceedings. The Morning Connection is a radio talk show, a program on Best 100 FM. We came together out of the need to have a platform from which persons could speak on what we generally describe as kingdom principles for the benefit of our listeners who are of a diverse ethnicity and philosophical inclination. We did submit the submissions which came out of our conversations with the listeners. Those submissions were submitted sometime in February of 2022. And in the conclusion to the submissions, we made reference to the fact that the amendments which were proposed, and there were 7 or 8 of them, favor increased severity of penalties, greater independence for the Commission, and increased documentation of procedures and timelines for the performance of the Commission's functions as being key to greater effectiveness. An issue that was resounding quite stridently may not be one for statutory amendments, but many of our listeners felt that the meaning of the words integrity and corruption should be more clearly articulated for common understanding. The cultural norms have corrupted the ordinary meaning of those words such that we see different standards applying to similar situations based on the status or identity of the persons involved. The sentiment is so overwhelming that many express the view that the passage of laws and conduct of consultations or on amendments, in other words, this process, are mere acts of futility in the absence of mutual trust and respect between the people and the state. Today, it is really a privilege to support those submissions with the following additional points. I do not intend to read the recommendations because you have them, but I want to emphasize who we are. Our team is a collective of legal, ecumenical, pastoral. Percival is actually a pastor. And business or man of the street skills and perspectives. Some of you may know I am trained in law. And this team was forged in the crucible of the pandemic when church leaders were seeking to understand fundamental rights and freedoms under our Constitution and how best to represent the interests of their constituents. And here you have already met Pastor Percival, Lowell Lawrence, myself. I have a special focus. I have been the subject of disbarment from the legal profession. I have been the subject of protracted litigation concerning the clearing of my own name. It took 5 years, and when my name was cleared somewhat, I still remained disbarred. The call for justice is personal from all of us. Pastor Percival has stood by and watched congregants die in the hospital, denied the benefit of comfort from their priests, while if your puppy got sick, you could get a vet to visit as an emergency service during the pandemic. Lowell, myself, as principals of Carousel, have had the unique experience of applying for, receiving a license under sanction in this very house. The license was revoked, withdrawn. The license fee remains in the coffers of the government. So we come with scars that are unique to our perspective, and of course our voice on the program which we host resonates very well with the experience of the public. Jamaicans are notorious for vocal expressions of interest, but short on focused, purposive dialogue backed by research and knowledge-based engagement. Radio talk shows have been a staple of the media landscape for decades, and they play an important role in the protection of free expression and the venting of pent-up frustration. Our listeners have been pressing for more talk, less talk, and more action. The promise of a great reset coming out of the pandemic coupled with the growing awareness that we are reaping the bitter harvest from years of neglecting certain foundation principles, has motivated this team to speak here today. There is tremendous scriptural foundation for the belief that an abandonment of the principles of righteousness, justice, honor, love, and mutual respect is the direct cause of the current decay in our society. Jamaica's national anthem is a prayer in which we invoke the wisdom and guidance of God to aid our efforts at nation building. The honorable member of this committee opened the proceedings with a prayer. Our motto speaks to the emergence of a unified nation from the mixed multitude of ethnicities which comprise our population. Our pledge invites God and all humanity to witness our commitment to stand for justice, brotherhood, and peace, to work diligently, creatively, to think generously and honestly in the service of our fellow citizens. Jamaicans of African descent comprise the overwhelming majority of our population, yet we remain landless, short on capital to fund our growth, failing in critical areas such as education, healthcare, and affordable home ownership. Innocent blood saturate our land. Our most vulnerable citizens, the children, the disabled, and pensioners, lack adequate protection, and corruption in high places is endemic. At a time such as this, there is a pressing need to be reminded of certain divine principles. Our show is notorious for speaking to the principles drawn from the kingdom of God and anchoring the behavior of man and the conduct of the public's business in those principles. The prophet Ezekiel was tasked to speak to the nation of Israel as the watchman on whose hands would be the blood of the condemned should he fail to speak. The throne of God is established on a foundation of righteousness, justice, mercy, and truth. Our constitution, motto, pledge, and anthem were culled from these enduring and indisputably infallible principles. The priest, scribe, lawyer, Ezra, was given the responsibility to read from the book of the law of Moses to the people in the re-established towns of Israel after the Babylonian exile. The prophet Jeremiah was led to warn of the judgment and the path to redemption in various public spaces such as the temple courts, the gates to the city, and the king's court. And in this case, I equate this house with a place in which these words, these warnings, these principles must be acknowledged. The Apostle Paul was activated into urgent and immediate ministry, spreading the good news that the way of Christ was the pathway to salvation or freedom. And that is our mission here today. The submissions on how this critical piece of legislation can be improved to deliver effective service to the people of Jamaica are self-explanatory. I have relied on my own technical expertise to propose a variety of amendments. However, the overall position is that the current iteration of the law carries only the appearance of virtue, not the reality or substance of it. What does the public demand of its leaders? Simply put, integrity. To the ordinary man, this means that we do what we say without making exceptions based on position or rank. It means the fair administration of public goods and services in all areas of life. It means timely and honest response to matters of public interest. It means that the entire government moves as one body applying the same principles. The Integrity Commission is seen as the conscience of the government, maintaining a balance between the interests of the people, the needs of government, and constraining the exercise of power by public officers. I had prepared just those notes because I wanted to provide a context, the context
Very
in which
extensive, actually.
we have made the recommendations which you have. Those recommendations have touched on some of the matters I heard discussed while we waited on the Integrity Commission to complete its presentation. And there are some similarities. Most notably, our listeners feel that the Integrity Commission itself requires additional work and focus. The Commission currently has the power under Section 6 to provide codes of conduct for all government agencies. Yet, Parliament itself does not have one. Ministries of government, many of them, do not have. And so, in our view,
So can we help in this process? I think you have a very extensive listing here of possible recommendations for amendments. Perhaps we might want to go through them.
Quick,
so,
yes. Yeah. Well, the first one that I commented on, which is really about the Integrity Commission itself being effective in its role under the current iteration of the statute. In Section 6 of the Act, Section 6(1)(g), they have the function of preparing codes of conduct and other advisory material and guide public bodies in respect of matters contained therein. I searched for a code of conduct which they have initiated, and I could find none. Perhaps it exists, and I was inefficient in my search. In terms of our recommendations, the first one that we made is that the Integrity Commission this particular piece of legislation should be considered in tandem with the other acts which form a part of the triumvirate. But I suspect that that is already done because I heard mention of the Protected Disclosures Act and the Corruption Act. I'll just go to them. Yes. I did appreciate your methodology, Chairman, so for efficiency, yes. The first recommendation which we made concerning Section 5, it is a Commission of Parliament. To the ordinary person, a Commission of Parliament is an extension of the parliamentarians, and it is subject or exceptionally vulnerable to political interference, if one could call it that. A certain degree of independence is what members of the public are seeking. I saw the committee grappling with the same issue, who bells the cat? And the idea of the commission itself reporting directly to Parliament and having that symbiotic, or not symbiotic, it's more like a parent-child relationship, raises the specter of political interference. So our recommendation is for it to be an independent statutory body and not, it could function somewhat
Chair,
like...
I'm so sorry. Please allow me to interrupt Ms. Lawrence, and,
yes.
I forgive me to do so, but I don't wish for incorrect information to be delivered to the public. A public and statutory body is not an independent body in the sense that you're speaking. A commission of parliament is what we have created in our legislative framework for the kind of independence that you want. A public body, a statutory body, has a parent ministry to which it reports and which orders and governs how it operates to some extent. It has a responsible minister. It usually also has a public board that is appointed by the minister. So I think the kind of independence that you're asking for actually sits in the context of its existing structure, not what you're referring to. A public body is not what you're calling it.
Perhaps, thank you, Member. Perhaps the difference in language nomenclature might be a continuing challenge because we are a parliamentary democracy, and so the kind of body that we would need might not exist in our current configuration. And that is indeed a challenge because most of our listeners and the comments we get, they speak to a republic being the ideal form of government under which such independence could be attained. Nevertheless, I am constrained to make the point that the relationship between a commission of parliament, which must lay its report, to deliver its report to Parliament, and is constrained by certain levels of authority, is the fundamental point at issue. However, it can be achieved. I am sure the draftsmen of the legislation can grapple with that, should it be received with favor. But the current version, or the current structure of the Integrity Commission, has it seen as an arm of government which reports to the Parliament when it is overseeing the work of public officers. So that inherent issue of conflict, which I saw you grappling with as Mr. Christie spoke, is one that is unavoidable.
Except that the definition of the commissioners and their role and where they stand in relation to even the Parliament itself gives them that stature and independence which enables them to adjudicate well on public matters. So I think that is corrected by structure. And I understand what you're trying to get at. but that operates in another system of government. So
Yes.
you're
And I
inviting
think,
a
sir,
constitutional reform
I
discussion,
think, sir,
which
yes,
yeah.
I think, sir, that is the fundamental point, which is a challenge as you go through the legislation, because we are what we are, and until certain other changes occur, we would not have the latitude to be as far-reaching. But I am being faithful in sharing the feedback.
And we take
the
the position that you have put forward in the spirit that you are making it.
I am grateful,
Chairman.
sir. There were other issues.
Sorry, Member Charles.
No, I'm just trying to be of assistance because, I mean, what is clear is that the intention of the recommendation is ultimately to seek as much independence in the process as possible. Am I correct?
Yes, sir, you are correct.
Okay, all right. So I would just refer to the comments of Member Golding, which would have treated with the matter as to the recommendation in its content regarding transition from a Commission of Parliament to public or statutory body. She dealt with that. I think that's agreed that perhaps that would be of no moment. But I think you're having a difficulty in how the word report is defined. And I think that perhaps in your interpretation you have considered report to mean some kind of account, some kind of daily account to persons who are managing the process. And perhaps clarity should be given to you in that that's not the case here. The Commission is quite independent in its activity, in its reason, in its function. But like any other body in our jurisdiction and others before us, even the Commission in its independence will have to report to the public, to the people. And the people elect the persons in this Parliament to be the representatives who will have to receive, hear, assess, and ultimately it is to achieve what you are seeking, which is an independence which does not lead inadvertently to this same Commission becoming a beast of its own. I don't think that's what you want either.
No, sir.
So perhaps, and I'm just, again, I am assuming a little, but I think I'm correct, based on your own comments, that the intention is simply to ensure that there is as little as possible conflict of interest, and that the Commission is not constrained or interfered with in its function.
In the proper discharge of its duties. You are correct, sir, and I thank you for that.
Yes.
I do know that there was the sense that oftentimes the Commission is weaponized against the citizen by one administration or another, depending on
There's
how...
a sense that what?
Weaponized. It is used in an attacking way.
This Commission, though. No, not this Commission.
I mean, if you were listening earlier, they take no direction from any parliamentarian. I mean, you can call for an investigation. They can choose to investigate or not. They can ignore it. But I want to be very clear. We have absolutely no authority whatsoever in relation to the work of the Commission. It's very independent.
I think a challenge I may well have is that as I make the comments, it may be taken personally, it would seem.
No, man, I'm not taking it personally.
Okay,
but I think the public needs to know clearly that there's no politician dictating to the Integrity Commission about what it should do.
So I thank you for making that point, because I am representing the perspectives of an audience that is larger than the three of us seated here.
As you do so.
Chair, I'm so sorry.
As you do so.
Members, let's manage this process.
I'm going back, Chair, to my point, as I was the one who was actually speaking before I was interviewed.
Member, yes. But we listen to submissions that are made. We see clarification as may be necessary to understand fully what the intent of the submissions are and what guidance we require to determine our own position on it by way of the reports that we make. So let's not make it a sort of a interrogative process, but rather make it be a process where we are seeking just to get better information in terms of the contribution that is being made by those submitting.
Chairman, my last comment. Again, I started off by saying I'm just trying to be of assistance because it is not difficult to appreciate the essence of what you are trying to submit. But as you do so, I believe that with humility, all of us here should be able to listen to our perspectives. And so I'm not seeking a banter. What I'm trying to do with my intervention, and I'm sure Member Robinson, Member Golding, is just to apply a level of clarity, because there is power in your perspective. And if it is not immediately rectified, because this is a public platform, it may leave others, even though it may not be your personal view, but a view that you are representing, it will leave persons who are hearing us with a misunderstanding as to the reality and the accuracy. And there's a need for correctness. So that's all that I was intending in my intervention, and I hope it wasn't seen as me trying to...
Oh, no, sir, and I'm grateful for it, because it is oftentimes the case that when you are listening to one thing, a lot of one thing, you can become blinkered, and I seek to resist that. But I am saying with all sincerity that I have received many phone calls where persons, even through the very program that we host, they make a statement which they are hoped will be picked up in some political arena and converted into an investigation or a story of some sort. And I am saying to you, if you're not aware of it, there is the perception that the Integrity Commission, much as you were here debating the necessity of maintaining discreet silence on the commencement of an investigation because it can make members vulnerable to allegations of impropriety that are not founded, there is the sense that when one wants to do a particular thing, it is enough to call for an investigation. And sometimes the call is answered and the public makes a connection which may not in reality exist. I think what it calls for is more focused public education. It may call for greater dialogue with the public so that we understand better what you're doing and how you're doing it. And it does not help that the Integrity Commission itself maintains a certain shroud of informality to how it approaches various things. I was present here when the member asked, what does it mean to have a waiver in respect of matters which are non-compliant with form, but have virtue in terms of its substance? And even to my learned ears, it speaks to a commission which wants to be free to avoid its own prescribed form when it has good intentions to accomplish something great. Most persons understand that form does not overtake substance, but there are occasions when form is critical to preserving the integrity of the substance.
I think, again, last thing, I think we might be conflating issues, but there's a need for us to recognize, most importantly, that the Parliament does not have any direct authority over the functions of the Commission, and that has never been proposed and has never been the reality. That's very important.
And I am not suggesting that, Honourable Member. I am saying only that the manner in which the Commission conducts its business can be improved by legislation that offers greater clarity is more structured as it approaches matters that affect public perception. This Integrity Commission is regarded as the conscience of the public conscience, and people look to it for consistency, for transparency, and on issues of accountability. It looms large on the public stage.
No, I'm just referring to what you have submitted. As I said to you, in a previous comment, there are a number of issues that you raised.
Yes.
And so there might have been some conflating there, but I'm just speaking to the issue that was before us, where you made a recommendation regarding Commission of Parliament to be given the Commission independent status as a public or statutory body, and then you went on to say that there's an inherent conflict of interest in restricting the Commission to a direct single-line reporting to the very body whose ethical conduct it is established to investigate and monitor. That's what I'm referring to. And I'm just saying to you, in relation to that which you put before us, not the several issues, which are relevant issues, but which you have discussed in your comment. And I'm saying regarding this, let it be very clear so that it is not said otherwise. And it is at item with what Member Robinson said, that the Parliament doesn't have that authority which this may presume that it has.
May I then qualify my comment, sir, and to the members?
Sorry, I just want to make a small point here. We cannot continue just along this line on the first. You have
and we're
several,
only at the first
exactly.
point. I appreciate it, sir. I will
Please.
move along.
I think what should be clear is the explanation that we've given concerning the position of the Commission, right? It's the nature of its structure, its reporting procedures, and its independence. And I think we've made those points very clear.
Chair,
so we can move on.
If I may, before the presenter continues, two things. And we have to be mindful of the audience in which this reaches. Secondly, she made mention of the numerous callers that come. And we know that there are times when there needs to be a correction of the facts as such. First of all, the Integrity Commission does not only investigate parliamentarians. We are a minute number of the individuals. It's all public servants whose salary is above a certain level that has to report to the Integrity Commission. There are 63 members of Parliament. There are thousands of persons in the public sector who earn and are investigated by the Integrity Commission. Secondly, she mentioned Section 5 and posit a particular view, that is Ms. Lawrence, a particular view. But I would encourage her to look at Section 6. At 3, in the exercise of its power and performance of its function under this Act, the Commission A shall not be subject to the direction or control of any other person or authority other than the court by way of judicial review, and that includes the Parliament, shall act independently, impartially, fairly, and in the public interest, and C, shall have the power to do all such things as it considers necessary or expedient for the purpose of carrying out its function. This, to my mind, speaks of the duties, the function, and the nature of this. So even though it's a commission of Parliament, it does not respond to the whims and fancies of the members who sit in this House of 63 members.
Members, I think we've clarified the position, sufficiently, and we can now move to the next recommendation that she has.
Thank you. I think the next recommendation of substance has to do with the prosecutorial powers of the Commission. I have it as Section 32. Please forgive me if any of the sections are misquoted, but here I would ask that substance overtakes form. This is the section which renders the prosecutorial powers of the Commission subordinate to the DPP, and we are recommending that the agency be given its own original powers and that a raft of remedies uniquely tailored to affect offenders in the pocket, the reputation, and career advancement be developed. To understand this point, it it requires an appreciation of the difference between criminal liability and the administrative action which agencies can take in order to safeguard processes. It would not be giving them the power to prosecute and pronounce imprisonment sentences, custodial sentences, but it would allow them to set rules of play that could influence how persons progress in their in whatever agency or wherever the public official works. A system of monetary fines and demerit points can be used in other places. It's called social credit, where you resort to using mechanisms that speak more to safeguarding the morality and the substance of what you're administering than to extract criminal penalties.
I would say on this one, you know, I'm a little bit sympathetic to the recommendation, but my understanding, the Constitution of Jamaica only gives the DPP the authority to prosecute, and as such, the Director of Corruption Prosecution is in fact subordinate to her in this regard. It's a constitutional provision, not one which the Act itself provides for.
Mm-hmm. In my consultation on the issue, the Office of Public, the Director of Public Prosecution's office and other persons who look at the area have sought to make a distinction between administrative action that can be taken and prosecutorial or criminal liability that is prosecuted in a particular way. There's a whole body of law that touches on how you can seek to enforce your policies and your guidelines without breaching the DPP's remit. It's worth looking at, and I'm sure those who are trained to do so.
I mean, for example, right now the Auditor General makes recommendations in her reports to Parliament, and she can recommend that a public official be surcharged. She can recommend administrative sanctions. Ultimately, yes, a permanent secretary, or I think the cabinet secretary, would have to decide on that. So there are administrative sanctions that can be recommended now for public officials if it doesn't rise to criminal liability.
Thank you, sir. I think we're saying those can be incorporated into how the Integrity Commission carries out its function.
Can I make a suggestion? Because I appreciate that, having had a number of engagements with your radio family, that concerns would have been shared with you in the context. I'm a little concerned that I'm not clear on the concern that is expressed. I am looking at a recommendation. And so could I ask you, we have about 5 more of them, I think, if you could just, in 1 or 2 sentences, indicate what is the aggregate concern that you got that led you to crafting these amendments.
Some of the amendments, some of the proposals are specifically what was advanced by members of the public.
And I just want to say this. I'm saying it in the context that I think I note a number of misunderstandings about the statutory and legislative framework of the Integrity Commission and other laws. And I don't want us to go through these each time misstating and furthering what appears to be a misunderstanding, certainly in terms of the question of independence. So I'd really appreciate if you would start from the position of their concern so that we could address either whether that concern is already satisfied or that is a concern that we now need to take a look at how to address, or in fact whether or not that the concern might have been addressed in the proposals that we have received and are currently under consideration.
to the member and the chairman, we would not have known the proposals that were made previously.
You don't know, but we know,
No,
so we want to be able to respond, because I don't want to be correcting the question of whether a public body is an independent body or not an independent body, and I really don't want the committee's time to be spent putting out misinformation, and I see quite a number of things in this submission that are simply not the case. So I want to hear the concerns of the public through you, but I don't want us to further what is not correct. Okay? And I could go through the document and highlight what is not correct. I don't want to do that. So can we start from the concern and then let the committee address that?
The concern of the public, and I thought I stated it, but perhaps not as well as I should have.
As you go through the recommendation, so for Section 32 proposal that you're making, we dealt with that. Section 34, what is the concern underlying this proposal?
In respect to, if you'll permit me, Chair, in respect to Section 34, I want you to point me expressly to the section that you say, where you say Parliament can compel the production of a report, if you don't mind.
You have it,
yeah, I'm pulling it up. While I'm searching for it to the member's question, the overwhelming sentiment is that the Integrity Commission is ineffective, that it is used selectively to and when I say used, who the user is not specified. A lot of the callers talk about they, and as you can imagine, there is a lack of trust in the system. I don't believe that I would be the first one.
Ms. Lawrence, I'm so sorry. I'm really asking you, and I have to be firm about my question. Please, can you talk about this specific recommendation? I know you spoke generally and you did contextualize the general perception, but in order to make useful time of this, for Section 34 that the member has asked you to indicate where this provision is set out, what is the concern in relation to Section 34 that would propel you to make this particular recommendation to remove the provision that Parliament can compel? And I don't know of that provision, so I too am awaiting you to indicate.
All right, Section 34 says, the Commission may at any time be required by either House of Parliament to submit thereto for tabling a report in respect of any matter under investigation by the Commission. That is the specific section. Well, the version of the Act that I am looking at, and I think that is an issue because I take it from the legislation on the Ministry of Justice website. I pulled it directly from the website with the invitation for persons to review and make comments. So I did ask to be forgiven if the sections are not correctly numbered.
You see that as Parliament having the capacity to compel? That is what you're...
May at any time be required by either House to submit for tabling a report in respect of any matter under investigation by the Commission. That section was tagged as one of the sections which could lead to the silencing of matters that ought to be in the public domain. I see members are taking issue with my choice of words.
No, it's not your choice of words. It's that we think the gap here, maybe you might be looking at an old version of the Act. Are you looking at the Integrity Commission Act of 2017?
I am looking at the Integrity Commission Act of 2017, which I pulled from the Ministry of Justice website.
That's not the provisions I'm reading at that section.
I want to intervene here because we need to hear through the submissions. We need then to, as a committee, absorb what you've said and review for our own determination down the road. So the purpose of your being here is really to indicate your concerns, and indeed if we have questions in relation to what's behind your concern, we raise them and then we move on. But we don't really want to spend the whole time backing and forthing and, you know, trying to define who you are and what you're about and so on. So I'm going to take the submission as you have, section by section.
Yes, sir.
And please be explicit, and let's not have this constant backing and forthing until we conclude.
I'm grateful, sir. I've been up since 4 a.m. So
right.
I am tired.
So Ms. Lawrence has the floor. I mean, is Mr. Simpson part of your...
No.
What? No, please. Your time hasn't come as yet. No, but I'm saying that in fairness, you have no locus standi in this meeting. In fact, this belongs to 100 FM. Right? So I really want to conclude this discussion. We're now 1:13, and we have another team to come before us. So, please go ahead now, starting just to clarify 34, based on the questions asked, and let's get on with 36, 39, and conclude this presentation.
Chairman, as you do that, can I also ask you then if Ms. Lawrence could, when she's finished, submit the copy of the act that she has reviewed? Okay?
Absolutely. Thank you.
That would make it more useful.
Yes, because I feel I'm in an adversarial discussion, and it was
You're
never
not in an
intended to be
adversarial
that.
discussion at all. I want to hear the concerns, but I think we're talking from two different versions of the act.
document.
So let's see the version that you have.
I'm happy to do so. Yes. So for Section 34, and it goes back to what the honourable member said may be a misunderstanding of what reporting means, which, because we're dealing with legislation and because public perception is important, and because you have the opportunity to offer clarity in how you express the regulations and the legislation, I'm merely putting forward the sentiment, the feedback that I have, that persons regard Parliament being the place where the reports go, not to the public. In fact, it is generally understood that until a report is tabled in Parliament, the Commission cannot speak on its work, and that is seen by many as an opportunity for information which ought to be in the public domain to be held hostage. And there I leave that particular recommendation.
So I'm referring to the section of the Act which I think relates to 34. And it reads, the Commission may at any time be required by either the House of Parliament to investigate a matter relating to an act of corruption and table a report thereon. And then it went on, the Commission shall, not later than 3 months after the end of each. So, in other words, you're saying that the Parliament could require. But then, of course, that's the purpose of Parliament. So, a Parliament along with other persons. But in this instance, the Parliament has the authority to require a report in a manner prescribed. And we're saying it could be 3 months, or, as you heard earlier, it could be daily.
Yes. Thank you, sir. And it is not to take away Parliament's power to do so, because why should Parliament be less than any other citizen? It is within the context of the Commission being silent or being constrained to be silent on certain matters until it has gone through the process that it engages with Parliament. Yes. 36 is a proposal about process. The Commission should elicit a reasoned response for whatever decision is taken, or they should provide a reasoned response for whatever is taken, whatever decision they take within a stated time period. And I've suggested 21 days really randomly. It's merely to say that the Commission can investigate or not, and it remains silent. In my own experience with them, they immediately acknowledge receipt of a complaint or a request for investigation, and thereafter they remind you of their powers. They can be silent, they can refuse to, whatever decision they take. I think modern democracy requires that a reasoned response is given so that a citizen is made aware of the position taken with regards to their complaint.
Actually, what you're saying here is that the Commission should be required to respond within a given time frame to any requests or submission that is made by a citizen or anyone.
Yes, sir.
That seems a reasonable and acceptable one for us. Okay, 39. 39.
Yes. In respect of 39, this is the area for administrative action, which I adverted to earlier, that there is a way to address delinquency in relation to certain matters which does not have to rise to criminal prosecution. I've made a suggestion. Breaches could be punishable by the imposition of daily fines for the period of delinquency. Demerit points can be accumulated. The social credit point is what is being emphasized here. Section, if there are no...
I think that Member Motley might want to ask you something more specific to help us to be able to understand where you're coming from. And what
the concern with that, and you know there have been many celebrated instances of reports not being published or submitted, and the public is often left with the understanding that unless the DPP elects to prosecute, that is the end of the matter. But we are in an age when persons are looking at these minor infractions as being oftentimes the tip of the iceberg, hinting at greater concerns which can go to the heart of the very corruption that we are seeking to police, to monitor, to eliminate. And so there is this sense that the Commission ought to have the authority to do more than simply wait until the DPP prosecutes, and that we could look to the social credit system, which is what the demerit points are about, as one way of coming up with administrative actions that can police that sector with greater effectiveness.
I see. I think you know, Member Golden did make the appropriate request, because as we are looking at the sections, they're pretty much confusing. The reference you make to 39 is actually 41.
And then I go on to 41.
And so on. So perhaps it might be that, you know, we go through what you have here in general, and you, in fact, come back with, well, at least offer to the committee in writing the specific sections of the law that you're referencing.
In fact, you know, Chairman, I think
because it does put us in a very awkward position to respond to you.
The sections are different, and apparently the wording is also different. Yes. So it creates a difficulty on our side to appreciate what it is that you are actually you are making.
Thank you for that. And may I say that when I embarked on this process, I tried to obtain the most recent. It is not an easy thing for a citizen to get the most recent version of legislation. You are driven to the Ministry of Justice website, and what you get is what you get. I think that certainly is an area for improvement.
But in our case, in fairness, if you refer to Ms. Douglas, the secretary of this committee, she would provide
I did not meet her until my submissions were in, and she gave me a very polite response. I did not. I'm learning today, and I'm grateful for the education.
I want to recognize what Ms. Lawrence is attempting to do. And I want to recognize it because we talk very often about the participation of the people in the business of the Parliament. And I want to congratulate you on taking note of the comments that you have gotten, on engaging through your media, through your forum, ordinary Jamaicans, so that their voices could be brought to bear here. But I am going to suggest, for the benefit of those people, Chairman, that we suspend, that you take a look, if you wish to take a look, to revise it, or to take a look just to sync the provisions so that we can have a proper and fulsome review of it. I want to do it justice, and I don't think it's useful to continue. So if, Chairman, at that point the written version would be sufficient, then I think we can proceed with that. If at that time the committee elects to wish to invite her back for queries on the submission, then we can do that as well. But let us not, I don't want to make a mockery of this, and I think there are important points that you have brought through the people in your constituent family that need to be considered by the committee. I love the fact, I absolutely love the fact that you have engaged, and I wish more of us through our different zones and neighborhoods and communities would do what you have done. Thank you very much for that.
You're welcome.
Well, I think that this is the kind of guidance that the chair welcomes, because, you know, we've been struggling to really respond well to what we know are genuine concerns that you have, but we need a format that enables us to respond, you know, very clearly and well, and to give you the best opportunity of advancing the views that you are putting forward, not just of your own, but from your constituents. And so I would, in fact, suggest that we do invite you back, because we will arrange for such a time, in which case you review your submission in the light of what Member Goulding has suggested, and then the committee will be in a better position to respond well to you and to give you the time of day. And I want to join her in congratulating you for coming forward, because, yes, that's what we're here for, to engage the public more and to benefit from feedback from all the areas of activity that we are involved in, the laws that we establish, the regulations that we promulgate, the policies that we enunciate, and the practices that we pursue. All of that, very important that we get fulsome response from the public. So we want to suggest, yes, very kindly, that you accept, and we will invite you back at another time.
Just one quick comment to the chair and to the secretary to the committee. The version that is available on the Ministry of Justice website, is this the same one? Because it says 26/2/2017, because there was something previous, because in order to have made it, we went to the website. There's a parliament website we need to go to. Oh, not the Ministry of Justice. Oh, that's interesting. See, that's again part of the challenge that we have as a country in terms of communication, in terms of the information being there. Because the truth is, a lot of people who would love to make just can't bother. They put it in German. You go there, you're trying to find information, and you can't bother. Another comment, which is, I think, very important to us and as parliamentarians, and you know it, there is a major trust deficit in our country at this point in time in regards to the leaders of our country, not only the parliamentarians, but in terms of the different persons who they see as leading the different sectors. And we have to acknowledge that, because if you are leading persons and they do not trust what you say, then you have a challenge in terms of credibility, and that's a very important thing that is out there in the public domain. Yes, thank you very much.
And may I say, Chair, that I'm sorry the minister is not here to actually hear that comment about the Ministry of Justice's website. But knowing him the way that I know him, his team is here, and they will certainly pass it on to him so that can be attended to, can be looked at.
Sorry, Chairman, if I may, just a brief comment. Right, it is not well, we're under the Ministry of Justice. But I think what may have happened is that if you do a Google search of Integrity Commission Act, one of the first results that comes up is the bill or one of the bills. And it's one of the bills that's on the Parliament's website. So on the Parliament's website, there's a section for public bills, and it lists all of the bills that have been tabled going back for many years. And there are two different Integrity Commission bills available in that pact. Under the section that deals with the acts, you go there, but you have to search by year in order to find it. On the Ministry of Justice website itself, there's no version of the, well, from my search, there's no version of the bill on the Ministry of Justice website. But you have to go on the website itself, go under laws, library, click search, you type in Integrity Commission, and the act itself will come up. So I think what may have happened is that the document was accessed through the Parliament website, not through the Ministry of Justice website, because I'm not seeing the bill on the Ministry of Justice website. And the Ministry of Justice website doesn't typically have bills. It usually has the enacted laws of Jamaica. So I think that's where the confusion.
But hold on, but let's be careful though, because we have to be careful about the information that we put out to the public, Chairman. There is a section on Parliament's website for bills, and the public needs to understand that a bill is legislation tabled in Parliament that is not yet passed. It may undergo several amendments before it is passed. There is also a section on the Parliament website for acts of Parliament. And acts of Parliament are those laws that have been passed by both houses of Parliament, both the House of Representatives and the Senate. And those acts are published under acts and assented to by the Governor General. Thank you for that, Member Guy. So that would be the final law that is passed by the Parliament, and that is the one you would rely on. The bills are put on the website so that the public can follow the discussion and the changes that take place over time. So we have to be careful about where you go to access. Indeed, I think Parliament does publish all the acts that are passed in relatively good time, Shani? Yeah, relatively quick time. So just to be clear about that, if it was a bill access, it certainly would not be the final law.
I think what has come out of this is very instructive indeed for us. And I think, as wearing another hat, I will have conversation with the Speaker and the Clerk of the House with regards to a public education program that may be overdue, so that more of this information is available to the public so they can take the right actions and that they can be far more competent in dealing with issues that are critical and important to themselves and their constituents. So I think that this session has been very, very useful indeed in more than one respect. And if nothing else, we certainly can leave with a certain knowledge that we have to step up on our public education program as to the process of Parliament, what's a bill, defining what is an act, to deal with when does a bill become law, and so on and so forth. And also to take another look at our website to make sure that they're up to date and have adequate and current information. Thank you very much, Mrs.
Thank you,
Lawrence,
Mr. Chairman, and the members.
100 FM. Thank you
Best
very much.
100.
And we look forward to seeing you again. Best 100.
Best 100
yes.
FM.
Very well.
Yes,
Thanks
thank you very much.
Bless you.
I think we're accepting your invitation, and I'm gratified by the members' suggestion. I will do as requested.
Okay, so can we invite Lance, Jamaica Lance? Oh, you're here. Oh, yeah. Well, it wasn't your time yet, right?
Thank you, Mr. Barber.
Sorry, can you just allow Best 100 to
leave?
Vacate?
Oh, and all right. I wanted to say something regarding the versions with their presentation. First of all, All right. Yeah, man.
Welcome, Mr. Simpson. The floor is yours.
Thank you, Minister. Before we get into the presentation, I just wanted to say, when you had asked them about the year of the document that they had and to make sure it was 2017, just this morning when I was looking to make sure that we had the right document to walk with for reference between our submission and the document, I found two different files that both said 2017. May very well be that, yes, one was the bill before it was passed, and then the other one is the actual act that has the seal on it and the Governor General writing a date on it. So I had wanted to make that intervention because they would have found a document saying 2017 because there are actually two such documents. But I think the legal team that was here had cleared that up.
The public notice was very clear in terms of which act, and he told you exactly where to find it, that they will find a copy of the act on the parliamentary website to give you the address of it and everything, under the heading publications. So I'm not sure where everybody went, but I think...
we went to the page that just had the calls for the public submission, so we just...
Anyway, here we are, and I'm happy that you now have whatever documentation you need, yes?
Yes.
Okay, proceed.
All right, so we submitted a document in writing, and we hope that it has been read. In the interest of time, we're going to focus on specific parts first to get them out of the way, because the motivation for these specific submissions are, well, for most of them in these two sections that we have, are rewording for clarity. The organization that we are representing is a grassroots network, 9 different groups, and each group meets on its own time. These are not legal experts or anything, and even the persons who compile everything, we're not legal experts. So we're representing the understandings held by the various people that are in the movement. So I want you to go to page 9 of our submission. That's the one, no, sorry. Yes, page 9 of our submission. That would be section 4 of our submission, where it says harmful actions against claimants. So 4.1 and 4.2 are not rewording for clarity. This is a suggestion, but the others are rewording for clarity. Section 37, subsection 7 prescribes a fine for up to $500,000 or imprisonment for up to 6 months for a person who takes any harmful action against any other person, including interference with the other person's lawful employment or occupation, on the ground that the person has made a complaint. We appreciate this, but believe that it could go further. So in 4.2 of our document, we say it's low. We note that the caps are only half of the caps to the penalties prescribed in section 37, subsection 4 for complaints which may not be true. We suggest that the penalty could be raised, but we didn't come to a consensus on what they should be raised to. But we're suggesting to raise them because there's another penalty in the Act that is actually higher. 4.3 in our document. Section 37, subsection 7 makes reference to interference with a person's lawful employment or occupation regarding someone who makes a claim. We would appreciate if this could be expanded to be at least as comprehensive as the things described under occupational detriment in section 2 of the 2011 version of the Protected Disclosures Act. And we have that on hand if you want us to refer to that. Would you like us to? Okay. So in the version of the Protected Disclosures Act that we're referring to here, it says, it describes occupational detriment, and it fleshes it out and sections it out. It means any act or omission that results in an employee in relation to his employment deemed subject to disciplinary action, dismissed, suspended, or demoted, harassed, intimidated, or victimized, transferred against his will, refused transfer or promotion, subject to a term or condition of employment or retirement from employment that is altered to his disadvantage, provided with an adverse reference, denied appointment to any employment, profession, or office, threatened with any of the actions specified in paragraphs A to H, and that's everything I mentioned so far, because I'm on point I now. And J says otherwise adversely affected in respect of his employment, profession, or office, including employment opportunities and job security. This is in the 2011 version of the Protected Disclosures Act. So we're suggesting that the same way this bill also makes reference to occupational detriment, that this comprehensive definition be included in the Integrity Commission Act. Okay, thank you. So 4.4, we also note that there's no definition of harmful action in 37 subsection 7. We note that interference with the person's lawful employment or occupation is an example, but nothing seems to give an idea of the scope of what else may be considered harmful action. So where you've mentioned occupational detriment and we're asking for an expansion of occupational detriment, we're also asking for an expansion or an explanation for what constitutes harmful action. So we'd like there to be a definition of harmful action, or at least an expanded list of things that may be considered harmful action in addition to interference with someone's occupation. Because occupational detriment is the only thing specified, but it's not defined. And then harmful action is not specified outside of occupational detriment. It's occupational detriment or other harmful action. Then, okay, thank you. So section 4.5 of our submission. We would appreciate the inclusion of a clause to serve the same purpose as section 17 of the Protected Disclosures Act, which states, where an employee suffers occupational detriment at or about the same time that he makes a protected disclosure, the occupational detriment should be presumed to be a consequence of the protected disclosure unless the employer shows that the act constitutes the occupational detriment is otherwise justified. For the purpose of the Integrity Commission, so I end quote at justified, sorry for not saying. For the purpose of the Integrity Commission, the clause would not need to be specific to occupational detriment. It could refer to an instance where a person is met with any harmful action around the same time that such person makes a claim, to allow for it to be legally presumed to be a consequence of making or seeking to make a claim. Now remember, we're not just launching this as a suggestion. This is based on something similar existing in the Protected Disclosures Act. So that goes through.
Just to give you a sense of where we go from here. All of these proposals that you're making, we're taking note of to then send to the Integrity Commission for them to review and to come back to us at another time in terms of whatever amendments could be made. Because we ourselves are guided in terms of the amendment to the law from the submissions and the Commission. But we will definitely be passing these on to them.
Thank you very much. I appreciate that.
So 5?
5, we'll go to 5. I just want to make a quick note. We had participated in a joint select committee before, and our suggestions did actually make it to the Sexual Harassment Act, and we thank the legislators that accommodated us at time for that. Senator Don Scott Motley was among them. I'm sure you remember that. All right, so moving on to 5. So this section 5 is on statutory declarations, and most of this is on rewording as well, for clarity or expansion or definition for clarity and so on. So 5.1, section 39 could be revisited. Rather than stating a requirement in section 39 subsection 1 and then an exclusion criterion in section 39 subsection 2, then an inclusion criteria in section 39 subsection 3 that is notwithstanding the exclusion criteria in section 39 subsection 2, the bill can simply consistently use inclusion criteria to avoid confusion. This will make it easier to add other inclusion criteria in the future if necessary. So instead of so we give an example. Instead of section 39 subsection 2 saying that I'm going to just refer to the subsections because this is all under section 39. Instead of subsection 2 saying that subsection 1 should not apply to persons earning less than a certain amount, and then having subsection 3 say that subsection 1 applies to persons who hold specific positions even if they make less than the amount stated in subsection 2, the bill could simply say that filing a statutory declaration is a requirement for persons earning above a certain amount as well as persons who occupy specific positions. So when you make an inclusion criteria, then an exclusion criteria, then another exclusion criteria, it can become confusing. For simplicity of wording and clarity, because remember we want public to be able to understand this easier. We think it would be better if this could just be reworded for clarity. So you just work with inclusion criteria as opposed to exclusion then re-inclusion. I want to know that that is being understood. Consistency and simplicity as well, because it's a little convoluted. I want to know that for the same reason. I want to ensure that I'm being clear in how I explain it as well. I think 5.2 is where we try to make it very clear.
Okay, well, what we're saying to you is that in fairness, having gone through all of your recommendations here, I think it is appropriate that they be passed on almost in full to the IC for consideration, because they would have to make the necessary adjustments and amendments to come back to us, and we act on that behalf. But I think that what you have done here is very useful indeed, and that we will make sure that the IC gets a full report of the submission that you have made.
All right, thanks very much. Continuing, so section 40 subsection 2 assumes that only close relatives who live with someone can help or be used to conceal assets. Section 40 subsection 2A allows a declarant to omit particulars of their spouse if they do not live together, and section 40 subsection 2B allows a declarant to omit particulars of their sons or daughters if they are adults and live separately from the declarant. These persons can still be used to conceal assets even if they live separately from the declarant. Now I understand that this is tricky because somebody in public office can have, say, a number of children that they don't really have any financial ties to anymore, and that for them to then go and declare, they have to go and investigate the children as well and so on. But we just want it to be noted as well that it is possible for somebody to conceal assets in the names of family members that they have that they do not live with and may not even be immediate family. We just want it to be borne in mind. We're not sure what recommendation to make coming out of this, but it's a concern we want to express.
They may have more than one spouse too.
Okay.
Except that the remit of the commission, and if you had listened to a response from Mr. Beresford this morning, the investigation powers are wide and deep and can go far. So I think that it will be covered by and large by the breadth of their span of investigation.
So for clarity, saying for the statutory declaration, it's kept slim for simplicity and speed. And then if they need to investigate, they'd investigate further than what needed to be declared?
They actually get third-party responses and act on it. So if somebody sends an information about you regarding some element of your assets, which they did not see appear on your declaration form, then they go check on it, investigate it.
Thanks much for that clarification. Section 40, so this is 5.4 of our submission. Section 40, subsection 3, requires gifts to be declared if they exceed $100,000 or an amount prescribed by the relevant minister. We believe it should also require gifts to be declared if the recipient is unsure of the value. So I don't mean if somebody receives something and they think, oh, I don't know what it is, but it might be worth only $5,000. But you can get a gift, it's probably close to the $100,000 and you're unsure of the value. I think in such a case it would be fair to require them to declare it. Because somebody could just say, oh, I'm not sure of the value of this, or I wasn't sure of the value of this, as an excuse to not declare it.
Chair, may I? That you were going to suggest that the 100,000 should be increased as a limit, because if you are to declare every gift that you get for 100,000, that's with the devaluation, that's really not much.
I mean, 100,000 is what, 3 months' salary for somebody on minimum wage? I don't think a normal person is getting $100,000 gifts.
You still have to be pragmatic. I noted you said that in your submission, but you still have to be pragmatic because you have to look at the objective which you're trying to achieve. And I feel that the 100,000 is just the ceiling. It should be increased. That ceiling.
I would say 250,000. I think if you look at it in the context of, what is involved in financing a campaign and those kinds of activities, I would personally go for a higher figure, like 250,000.
We don't have the authority to really agree because nobody had expressed that before and we can't alter. But nobody had expressed an interest in raising the limit. And they made a point that the limit, they believe it's already high, which is why the reference was there to the 3 months. And it's also stated in the document, whatever value someone gets out of such a gift surely outweighs the perceived inconvenience of having to declare it. I don't think receiving a $100,000 gift is something really normal, to be honest.
Today's prices, believe me, that's nothing. Anyway, I think we understand what you're saying. So and one of the things that we have to guide ourselves against is to make it so ridiculous that, it is of no value. Because at today's prices, what it would mean is anything that you get, you'd have to declare. And I'm sure that's not what is intended.
Okay. That was on that was on 5.4 of our submission and 5.5, but before I move on to 5.6, another point we made in 5.5 was that section 40, subsection 4 should be removed. A relative can still give someone a gift in hopes of some benefit in return which may influence a public official's behavior in a case of conflict of interest. So somebody can give their sibling a gift and hope in return that that sibling, if they're involved in some process of giving some benefit, would. Or it don't have to be somebody as easily, them as a sibling, but you could still have a cousin or something, or some relative.
I think that one of the things, too, that we have, we go back to what is practical and pragmatic. And one of the purposes of creating these regulations and laws is not to make it impossible for people to serve, but it is to ensure that they serve with integrity. So I think you need to bear that also in mind when you become so granular in terms of these specific areas.
Okay. These still are just suggestions, so where they reflect a certain concern, you could find another way to address it if possible, but just want to ensure certain bases are covered in terms of, in the same way we're being asked to be mindful of what is pragmatic, that there's mindfulness as well as to say what the concerns are that this is going at. So the concern being expressed here is that a relative can still give someone a gift in hopes of some benefit in return, which may influence a public official's behavior. That's the concern. So even if the recommendation is too granular or harsh, the concern we'd like to not have. We'd like to not have the concern itself dismissed.
We're not ignoring the concern.
Oh, good.
Right.
I just
We're giving
want
guidance.
to make sure it's not. Thanks. So on 5.6, this one is a case of rewording. Section 41A seems to be saying that someone should file a statutory declaration at the end of the year if they had been holding office before the midpoint of the year, which would be the end of June or the start of July. That is, someone should file a statutory declaration at the end of each year unless they just took office recently in the second half of the given year. It can be reworded for more clarity and ease of reading.
Any suggestion?
Well, for that, give me a second. We hadn't put a suggestion in writing, but this isn't a substantive point. It's just one for clarity. So once we're sticking true to the same meaning of the original thing. So it's saying that someone should file a statutory declaration at the end of the year if they have been holding office before the midpoint of the year, right? That's not the exact wording. Let me just quickly consult the Act for the exact wording. Because what we're citing is what it seems to be saying. So in the exact wording, and it's pretty lengthy, this is on page 30 of the Integrity Commission Act. This is section 41. This is subsection 1 saying, subject to subsection 2, a statutory declaration required to be submitted pursuant of this part shall be made. A, in the case of a person who is elected or appointed as a parliamentarian as at the date of such election or appointment and thereafter. 1, where the election or appointment was at any time after the 30th day of June in any year, or as at the 31st day of December in the year next following, and thereafter as the 31st day of December in each year during any part of which he remains a parliamentarian. Or 2, in any case where the election or appointment is at any time in a calendar year other than that referred to in paragraph 1, as in the 31st day of December in that year, and thereafter as at the 31st day of December in each year during any part of which he remains a parliamentarian. 3, as at the end of 12 months from the date on which he ceases to be a parliamentarian. So we're asking for that to be reworded. Because as we didn't even cite this in full in our document, what we said in our document is that it seems to be saying once somebody has held office in the second half of a given year, they should be required to submit a statutory declaration for that year. No, sorry. I had it mixed up. Other way around. Once they had office before the second half of the year, they should be required to submit a statutory declaration for that year. But
clear? So that if you are before June, prior to June, if you're appointed prior to June, then you have to file by the 31st of December. The 31st of December. And if you are appointed after June, you file for the 31st of December the next year. That's what it's requiring.
Yeah, Well, yeah, the other conditions I see in number 3, as at the end of 12 months from the date on which they cease to be a parliamentarian. It is, I just think it could be more clear. As in the wording, it's kind of, for what it is saying, it is quite a lot. I don't think many persons would instantly get this from reading it. It was a little confusing for us, but yeah, when you take a careful look and read, yes, which is why we're able to have the correct interpretation as we say it in the document. We said it seems to be saying this, but we just think it could be given a little simpler wording for simplicity. So just a consideration to see if it's possible. If there's no simpler wording that could be given without changing the substance, then leave as is. But if there can be simpler wording, we'd appreciate that.
We take note.
Okay, thank you.
So 5.7.
All right, 5.7. Now this we can.
Yes, you wanna come in? Come and sit down. Come on.
we can skip this. This was where this may get confusing is with the issue of, say, perjury, persons doing self-incriminating information. But what it was saying is that there's a section of the bill that says public officials shouldn't be forced to declare anything, where we're saying persons should only be protected from declaring anything that is false.
You can just find that section of the bill that you...
Section 48, subsections 5 and 6. Let me scroll to...
Once you have documents which are subject to legal professional privilege, it does not just involve you as a parliamentarian, it involves the attorney. I think that is a hallowed principle, and I don't think that that can be disturbed, quite frankly, as is the right to self-incrimination. There are instances under... Sorry. Hi. There are instances in criminal law where if you make a caution statement or you say something voluntarily, it can be used against you. But I think this is a very important principle which we should keep. You had said that you were not proceeding in relation to this one. So
yes, right. I think in a case like this, what I think would be important is if there was public education around the importance of provisions against self-incrimination. So persons understand what that is. Because one of the things persons may think that means is that somebody can't be forced to declare something that is true if it would prove them to be guilty. And most persons are not so well versed in legal principles and legal terms and so on. So public education around this in particular would help. And it would help in other ways beyond the scope of this bill, well beyond the scope of this bill, in getting persons to understand the judicial system in general.
We take your point on that, Mr. Simpson. I think you can move on.
All right, thank you. We're not going to go on 6 now. 6, I think, has been belabored by other submissions already. So we're going to go to section 1. So there had been a suggestion to add INDECOM to the list of bodies which are deemed competent authorities in section 7, subsection 17, or at least a statement of an explicit reason that they're excluded. If there is a reason that they're excluded from the list of competent authorities, or if there's a lack of a reason for them to be included, the reason we're asking for a statement of an explicit reason is that we ourselves can better understand that. This suggestion was made from our group that's based in St. Catherine, but it was one particular group that made this submission. They wanted INDECOM to be listed under the list of competent authorities that the Integrity Commission would collaborate with. So is it that there isn't a need, or is it that the functions wouldn't complement each other or overlap in certain investigations? It would better help us to understand both the scope of INDECOM and the scope of the bill. Section 7, subsection 15, that's where you have a list of bodies deemed competent authorities. That's section 7, subsection 15 of the bill, not, yeah.
I am not so sure that I understand the rationale behind the INDECOM when you look at the purpose of INDECOM. But if members have any questions on that? Okay.
All right, taken. So we don't have the rationale here in the document. You'd have to go back to the meeting that they had and look over their notes. But that we would have remembered closer to the time we were originally supposed to make our submission. So apologies for that. But yeah, they had wanted to know if the case is that the scopes won't overlap at any point. Then
well, just remember this, that INDECOM is a body that investigates extrajudicial killings, it investigates abuse by the security force. So it's not a body involved in looking at statutory declarations and administrative matters like that. So I don't know that it would be appropriate to include it.
All right.
Yeah.
That's a satisfactory response. We'll pass that back on now. So we'll note that, pass that back on. That very much makes sense in how you put it.
Okay, so we can move on.
So 1.2 in our submission, we're concerned about the different possible implications of Section 4. Implications meaning what can be implied. While we recognize Section 4, subsection 2 allows the JCF to request the Integrity Commission begin or continue investigation of something, we would also like assurance that it will not allow JCF to stop the Integrity Commission from investigating something that it has already begun to investigate. To this end, rewording for clarity would be appropriate. So in this case, it's just a matter of adding words for clarity, not something that we think the bill is saying that it's not.
I think that's already included in the Act. The Commission is not under direction or control of any.
And it couldn't be restated
if
here
I remember
for reference.
Is it section? Sorry, yes. Yes, in the exercise of its powers and performance of its functions under this Act, the Commission shall not be subject to the direction or control of any other person or authority other than the court by way of judicial review. B, shall act independently, etc. And C, shall have the power to do all such things it considers necessary or expedient. So while the JCF by 4.2 may request, and notice the language, request the Commission to investigate something, the Commission is not compelled to accept or to grant the request, and if it does grant the request, how it operates, whether it ceases an investigation or how it concludes an investigation, is not at the behest of the JCF or anybody else for that matter. So it's already contained in the Act.
All right, thanks for that. So 1.3 now. Section 7 subsection 3 says that the court may order any person or body to provide to the Commission any information or document which the court deems necessary to assist the Commission in carrying out its functions under this Act. We would like clarification on whether there's a time limit for a person or a body to provide the Commission with such information, and whether there are any penalties for failure to do so without satisfactory explanation by the mandated time. For satisfactory time, we believe that 2 or 3 weeks may be appropriate. If it's a case where the court is supposed to specify a time, that would be a good explanation as well. But even then, would there be any penalties for somebody who fails to provide the Commission with anything that the court orders them to provide?
That's usually subject to the judge.
Mm-hmm.
The judge decides what the terms of the order are going to be, and usually the order is made with the party required to comply with the order within a specified time. But that is solely up to the discretion of the judiciary and not the purview of the Parliament.
Okay, so in such a case, if the person doesn't comply and hand over whatever to the Integrity Commission, it would be an offense against the court.
Then they're in contempt of court,
okay,
for which there are processes that can be engaged and
Understood.
are engaged.
All right, so section 2 of our submission, appointment to the Integrity Commission. Some members of our movement do not trust politicians to be responsible for the appointment of a supposedly non-political body. Some persons believe that there should be greater involvement of the Auditor General and the general public in the process for appointing members of the Integrity Commission. Some persons had at some point even suggested elections, but we went through that, and that we found that wouldn't make that much sense because, the MPs themselves are elected. this again is reflecting the views of some members. It's not all or necessarily a majority, but it was a recommendation made by a sufficient number that we could not just decide not to carry forward.
Well, what would you recommend then as an alternative? How would the general public participate in the selection? What mechanism would be used?
I think that now is this. I think this now is a case where what we would be concerned with is what we want to advance more would be the concern than the recommendation. And in this case, I think the concern would be a concern of public trust. So I think in this case, what can be done doesn't have to necessarily involve the public more in the process for selecting, but what can be done is to make the public feel more connected at least. So inform the public of who the Integrity Commission, who the commissioners are, what the profiles are, why they're being appointed, as in more public campaigns, so these persons are more well known. There could probably be as well, as we suggested in other documents, possibly, how do I say this? Mechanisms for expressions of no confidence by the public in an institution, even if they don't end up using it. Having something like that will make people feel that, okay, if they're dissatisfied with function of somebody in a public office, they can actually do something about it.
And you also asked for the greater involvement of the Auditor General, who already sits on the Integrity Commission, and certainly in the past, I think previous Auditor Generals have sat on the Integrity Commission as well.
All right. But separate from sitting on it, the recommendation these persons made is that the Auditor General be involved in the process for appointing the other members. But I do see how that would be some advance with.
Remember, the function of the Auditor General, is to audit processes for the various for compliance with various policies and laws and procedures. So the auditors generally ought not to be involved in the making of the process or the execution of the process. They're auditing themselves when they do that. Your Auditor General sits outside and looks in.
All right, understood. So I'll pass that on back as well. Much of this is appreciated. Wherever a misconception or a misunderstanding exists, or where we just simply don't understand something, having the feedback and clarifications helps, because we bring that back and then everybody else's understanding is bettered. Section 8, so this is section 2.2 of our submission. Section 8, subsection 1B3 allows the appointment of persons who represent non-governmental organizations that appear to be well established. We would prefer if this was removed entirely or at least amended. If it is to be amended, we would like it to specify that only representatives of NGOs that are not foreign funded may be eligible. That is, representatives of foreign funded NGOs should be disqualified.
Why is that so? I mean, we do have NGOs here that do attract foreign funding from various entities. Why would you say they should be disqualified versus a locally funded one?
In two of Jamaica's closest neighbors, and we're compiling intelligence reports on this that we can provide to you at a later date. My comrade here is responsible for that. And we've been in talks with even some persons from one of the parties about this. So we could speak later. Foreign-funded NGOs have been used as vehicles for foreign intervention and even destabilization of countries. It is weird to us, and because of our own political positions, to have them involved in any sort of process of accountability, because primarily they're accountable to their funders. There is even somebody in a local NGO who admitted that their priorities, what they're allowed to research and look into, are dictated by whoever they get funding from. And the primary persons and entities that fund them are foreign-based. And we don't really believe they should hold as much weight in civil society as they do now.
Is the issue foreign, or is it the entity or the individual who is funding, because a similar issue could arise with whoever a local donor is. So more importantly, I think you would want transparency about where the source of funding is coming from to ensure that there is no ulterior motive by the funder in dictating what the organization does.
That's a very valid point. We are critical of NGOs in general as well, because apart from foreign funding, they depend on funding from the local private sector, which can sway the interest. But which is why this did say we'd prefer if this was removed entirely, or at least amended. And if amended, cutting the foreign funded ones would be the compromise.
I was not a part of the deliberations about this legislation, but don't you think it is of significance that the criteria is that they be well established? Because, of course, you would have had an opportunity to observe the stances that they would have taken over a long period of time?
Is well established defined? Because even then, you have what we would see and refer to as well-established NGOs that we believe are compromised by foreign funding. And I think to go back to what Member Robinson said, these are funded by specific bodies that we have issues with. So because of their actions in sponsoring political violence and destabilization in other countries.
That's the funders you're talking about. Okay.
Yes, the funders have done that, and because of that, we believe that NGOs funded by these same bodies are compromised.
Okay. All right. I think we can move on to the next one.
So yes, even in 2.4, we have noted that NGOs tend to be accountable to those who fund it. Right, so moving to 2.3, Section 8, subsection 2 refers to NGOs as organizations that are not formed for political purposes or for supporting an organization formed for a political purpose. But there's no definition for political purposes in Section 2 or Section 8 of the bill. So in this case, all we're asking for is addition of a definition for political purposes in either Section 2 or Section 8. And it's not necessarily straightforward, because political purposes can be contesting elections. Some persons have a narrow idea of participating in politics as contesting elections. Some persons may have a wider idea of what forming a political organization is, or an organization for political purposes, because it can be spreading a particular idea or ideology, organizing a particular social base. So we'd want political purposes to be explicitly defined.
Okay, Mr. Simpson, can I just ask you how much more time do you think you're going to need? I'm cognizant of the hour and the fact that our administrative staff of the Parliament and the committee staff has not, we haven't broken for the day yet. So can you just give me an indication?
This can very well be our last point once it's responded to, because the...
Okay, proceed.
Okay, so yeah, this same one, just a definition of political purposes. Because 2.5, we'd rather not read that out loud, but we still are content with it being in writing for you to see. But yes, we want a definition for political purpose in Section 2 or 8. And then in 2.4, we're just noting what I had already said to Member Robinson. We understand and appreciate the point of subsection 2 of Section 8. We're concerned about uncritical acceptance of NGOs as somehow more trustworthy than political organizations or other categories of persons who are not listed as being eligible for appointment to the Integrity Commission. Section 8, subsection 2 notably says nothing about foreign funding. Whereas a political organization is accountable to a membership base that may consist of average members of the general public coming together for common values, an NGO is mainly accountable to those who finance it. Political organizations are instruments for representation of the people, while NGOs tend to be instruments for the exercise of power by the private sector and foreign interests. there should be more scrutiny of NGOs, especially regarding where they receive funding from. So this, I mean, what Member Robinson here said, we've said it here as well, private sector, which would be local, and foreign interest. So we want that to be noted. So going back to 2.3, we just want definition for political purposes to be outlined in the bill. But we can end our presentation there. And of course, pending whatever responses you may have.
Okay, I want to thank you. Thank you for your comments, your recommendations. I can assure you they will be a part of the consideration and deliberations of the committee once we have completed this part of the process. Okay. All right, members, do we have any other questions, concerns? No? In that case, thank you all for coming. Thank you, Mr. Simpson. And I can have a motion that
Just before.
I'm so sorry.
By way of housekeeping, we reconvene tomorrow at 10 a.m., at which time we will take the NIA and the Jamaica for Justice, is it? And the submissions have been circulated. So please have a good evening, everyone. And thank you, Land. Yes, thank you very much. Okay, this meeting is adjourned until tomorrow at 10 a.m.
Something is happening for someone in this country every single day as a result of the actions of this government. The beneficiary of this house and the hundreds of people who have benefited so far, they feel good and their families feel good.
Oh, I'm on top of the world. It's just a dream come true. Somebody see that me deserve it and then brought it to life for me.
There was no schism, there was nothing there, and it was just, okay, you're in need. And